Good morning. The District Court of Appeal of the State of Florida and in for the Second District is now in session. The Honorable Daryl C. Casanueva, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, and on behalf of the panel, we welcome you to this remote oral argument session of the Second District Court of Appeal. I will be calling the cases in the order that they presently appear on our docket this morning. Hopefully that will help you to arrange your time and know when to be in whatever place you are located electronically before we bring you over. I would point out that there will be a brief pause as you are transitioned into this virtual courtroom. And after each case is completed, the participants will be asked to leave the meeting with the understanding that should you desire, you may continue to watch the remainder of the proceedings online. The cases will be run as always. Each side is afforded 20 minutes, and the appellant is able to reserve up to 5 minutes for the rebuttal. If you know at the beginning of your presentation as the appellant how much time you'd like to reserve, please let me know, and if not, most likely I will ask you. I will do my best to notify you as you desire so that you can use your time in your best professional skill set. One thing I've noticed over the times that we've done that, please try to remember to unmute your microphone. Having failed to do that on occasion, I will be glad to let you know when you do it so that you can let me know when I do it, or whatever, so that we can all speak with one another. At this time, I thank you. Look forward to hearing your presentation. We are ready to proceed. The first matter on our docket is Campbell versus Wells Fargo Bank. Okay, we have our oralist here today, Mr. Rosen. I believe you represent the appellant in this matter, and did you wish to reserve time for rebuttal?
Yes, Your Honor. Scott Rosen for defendant. If you can reserve 5 minutes for rebuttal, please.
Okay, I have made a note, and I think with that being said, we are ready to begin.
Okay, may it please the court. Your Honors, if you'd let me allow me to start off by laying a proper foundation for this case. If you closely examine the record, you'll discover this is unlike, I believe, any case that this appellate court has heard before. What makes this case unique is the defendant has uncovered fraud from the inception of the attempted origination of the loan and throughout this foreclosure process. Yeah, Your Honor, there are so many issues in this case. I know I can't possibly hit them all within 15 minutes. One of the most significant areas is the fact that the final judgment is completely devoid of the word allonge or certificate of possession.
Mr. Rosen, I want to stop you before you get too far into this because I have a question.
Yes, Your Honor.
That I want to make sure that you answer. On the very first page of the appellee's brief, they say that Campbell purports to raise 8 different issues on appeal, all of which assert that the trial court improperly weighed the testimony and evidence in its role as finder of fact. And to be candid with you, I don't disagree with that statement. So I just want to give you a heads up on that and give you an opportunity to respond specifically to that.
I'm sorry, Your Honor. Could you repeat that? The gist of the argument? I'm sorry. Say it
Which
again,
part
please.
do you want me to repeat?
Which part is it in the brief? The 8 points regarding.
Okay, I'll read it again. This is on the very first page of the appellee's brief.
Okay.
Campbell purports to raise 8 different issues on appeal, all of which assert that the trial court improperly weighed the testimony and evidence in its role as finder of fact. Personally, I tend to agree with that statement. So I want to give you an opportunity to respond specifically to that during your argument today, please.
Okay, thank you, Your Honor. Yeah, Your Honor, there are several issues of fact that clearly weren't even addressed by the court, especially, as I was mentioning, the final judgment is devoid completely of the words allonge or certificate of possession. There are actually 3 allonges.
How is that illegal? How is that a legal error?
Yep, allonges, Your Honor, are permanent fixtures to the note. They can't just disappear. There was an original complaint.
No,
and
no,
an
no,
amended-
no. I think you misunderstand my question. How is it a legal error that the trial court did not reference it?
Yeah, because we believe that the plaintiff is coming to the court with unclean hands. The state court didn't even address the fact that there are 3 allonges. There's one certificate of possession, for example. The same certificate of possession is used for the original complaint and for the amended complaint. The original complaint has different attachments to the note, different allonges than the amended complaint does. Yet the certificate of possession says that under penalty of perjury, the representative states that attaches a true and correct copy of the note, with all the attachments, when there's clearly different allonges to the original note and to the amended original complaint and amended complaint. The allonges, of course, Your Honor, are permanent fixtures to note. They can't just be taken. The first allonge, actually signed by Mr. Wantland, was not even what I refer to as the first allonge, signed by C.A. Wantland of Wantland Realty Corp. It was not even attached to the original complaint, and it was not even attached to the amended complaint. The plaintiff hasn't provided this allonge in the course of their entire case, yet it somehow exists. The defendant obtained it prior to the inception of this case by sending a request for information to Wells Fargo. Wells Fargo provided him with a copy of this allonge. Plaintiff hasn't acknowledged in the original complaint or the amended complaint that this allonge even exists. And of course, according to the DCA and Florida statutes, the first allonge should still be permanently fixed to the alleged original promissory note. It's a permanent fixture. There's a second allonge, Your Honor, it's nonsensical, I call it. It was attached to the original complaint, and but it was not attached to the second complaint. This allonge was actually included in the original twice, but somehow mysteriously and permanently removed from the promissory note contained in the court file. My client had hired experts, forensic document experts from Hindsight Imaging Inc., to scan the note for document, for forgery, for analysis, whether or not it was original. They went to look for this allonge, but it was missing. It was actually taken out of the court file. Somehow just disappeared in thin air. The bank's rep, Jessica Reef Jones, testified at the trial that the note, and the note I'm referring to, I call it the second allonge. This allonge is nonsense in the sense that it was signed by my client as president of the lender, WRC Mortgage Corporation, which of course makes no sense. Originally, my client acknowledged in a deposition that he must have signed an error. There must have been a misprint, and he signed a lot of documents at closing. However, later, of course, when my client discovered fraud, numerous issues regarding Wells Fargo, and that's prevalent throughout this case, he realized that this must have been yet another document that Wells Fargo created and forged his signature on by mistake. At court, Jessica Reef Jones testified the document was removed because it wasn't needed. That's the trial transcript on September 18th at page 361. She testified the allonge was removed because of my experience of doing this particular job and looking at the document and understanding what the document was indicating, that it made absolutely no sense as far as chain of title transfer. It would go to
Let me just interrupt you just for a second. So is your argument that the trial court erred in not giving sufficient weight to that testimony?
Well, correct. Or the trial court erred by not throwing out the case because the plaintiff is committing fraud. There are 3 allonges. They should all be attached to the note. The plaintiff can explain away this one, maybe this was a mistake. They can't just say, we removed the allonge because obviously it was a mistake. The bank should have an error sheet, a errata sheet that shows any discrepancies in the case. If credit was given for insurance monies, something to that effect. There's no errata sheet showing that allonges were removed or why they were removed.
Mr. Rosen, is what you are asking this court to do is to read the transcript of the proceedings below and reach a different result?
I would ask the court look at all the evidence, Your Honor. I mainly addressed everything in my
Well,
brief.
I'm concerned about what standard of review we are to apply and what authority we have, as you are suggesting, to weigh the evidence. I'm not aware that we get to reweigh the evidence that the trial court considered. As the trial court, the case law says quite regularly, is in a better position to see the witnesses, hear the witnesses, and evaluate their testimony.
Yes,
So
Your
how
Honor.
do we get to the point where you want us to get?
The problem is, Your Honor, is that the trial court ignored a large portion of the evidence that weighed heavily in the defendant's favor. For example,
Well, you say ignored, the other side's going to tell us did not give credibility to. Isn't that what the trial court's task is to do?
Yes, Your Honor, but I don't know how the court cannot give credibility to the plaintiff's own allonges. It was their allonges that they prepared, that they attached to the note. It's not something that the defendant prepared or the defendant relied on. It's something that the plaintiff relied on. Just like with the certificate of possession, Your Honor, the facts are clear that instead of obtaining an updated certificate of possession to match the change in allonge attachments, there was a change in attachments to the note of the allonges between the original complaint and the amended complaint. Yet they used the exact same certificate of possession. My client actually went so far as to take the deposition of Linda Tang, the person who signed the certificate of possession. And she acknowledged that when the second amended complaint was done, she hadn't worked for that company for at least 6 months. She hadn't even worked there anymore. So that's why, Your Honor, we believe the plaintiff is coming forward with unclean hands. I mean, the certificate of possession specifically says on its face, paragraph 2, a copy of the note with all allonges, if any, is attached hereto and incorporated by reference as Exhibit A. But it wasn't. There are 3 allonges. And the plaintiff didn't dispute the allonges exist. But the plaintiff's representative even said at court that the document made no sense and that it was probably removed, I believe she said, because it didn't make sense, it didn't belong. It should still be attached. It can't just be removed. You can't just remove a permanent fixture to the note. That's one of my big positions, Your Honor, regarding the certificate of possessions and the allonge to note. Also, Your Honor, of course, is the issue.
Well, let me ask you this, counsel. What does the UCC and Florida statutes require if an allonge is not on the note? Does that impact the note's ability to be negotiable? Or what does it do to the note under the statutory code? We've adopted provisions of the UCC in the 672 area of the Florida statutes.
Yes, Your Honor.
So if the allonge is there, does it affect the negotiability of the note? You're arguing that it makes the absence of the allonge makes the note entirely a fraud?
No, Your Honor. The fact that it wasn't, the allonges weren't attached is where the fraud comes in. The plaintiff can't pick and choose what documents are strongest in its favor. Just like part of our argument goes to the fact about hindsight imaging, doing the forensic document analysis.
But even if the plaintiff did, as you argue, the note and the missing allonge was brought to the attention of the trial court, and a fact pattern was given to the trial court to consider. Is that correct?
Yes, Your Honor. Yes, Your Honor. And my point is that the final judgment doesn't even address the issue. It just skips over it as if it didn't exist, as if it's such a minor issue that I'm not even going to mention it. And if I can too, move on. With WRC Mortgage Corporation, for example, the originating lender, that corporation didn't even exist. There's an undisputed fact throughout the collection of Campbell's loan documents that WRC Mortgage Corporation was a previously administratively dissolved corporation. There was nothing filed in the complaint, no separate count for reformation of the mortgage, no separate count to modify the note for purposes of getting the correct name original entity on the note. The court actually specifically denied plaintiff's Ortenis motion for leave to allow the pleadings to be amended to conform the evidence with regard to WRC Mortgage Corporation as the fictitious name of the plaintiff. And we believe, of course, the note mortgage cannot be transferred to an entity that does not exist. It's interesting to note too that Calvin Waltman actually testified. His deposition transcript was read into the record. We did not operate as WRC Mortgage Corporation, nor were we filed with the state of Florida to operate under that name. A corporation, of course, that has been dissolved cannot continue in business. And you cannot, the plaintiff's argument, I realize, is that it was a fictitious name. They were doing business as WRC Mortgage Corporation. You cannot have a fictitious name as a corporation. Corporations cannot be used as fictitious names. My client also, just before the trial, 2 days before the trial, which he did testify to this, he began an investigation of the public records in the state of Florida. He discovered an additional 64 mortgages using the WRC Mortgage Corporation name, spread out over several counties between the years 2005, 2008, which I believe impeaches Calvin Waltman's testimony of it being a mere scrivener's error. My client, unlike most defendants, my client, as soon as he discovered some issues early on, he questioned the validity of the mortgage and note with the Wells Fargo and with the fact that WRC Mortgage Corporation didn't exist. He sent requests to Wells Fargo that were never answered in order to, I actually sent a detailed 50-page verified notice in 2014 demanding Wells Fargo prove the rights to the note according to the UCC. The court heard all this, but they didn't address the defendant's arguments regarding failure plaintiff to reply to the notices by defendant and the effect and consequences of plaintiff responding by actually providing forged or inexplicable allonges. My client had actually hired an attorney. He was about to file a declaratory action against Wells Fargo in order to get to the bottom of things when he was actually served with a foreclosure case. My client also discovered early in his investigation that the endorsement allonge had an image of the signature. I'm sorry, excuse me. My client also hired Hindsight Imaging Inc. in order to do a forensic document examination of the note. They use this advanced technology, hyperspectral imaging and optical coherence tomography, to scan the note to determine that the note being offered to the court as the original is not an original. It's actually a fabrication. Dr. Benjamin Bird was admitted under the Daubert standard as an expert in the field of hyperspectral imaging and OCT. The trial court heard his testimony, yet found that his conclusions didn't match the evidence. The evidence showed that there was a signature on a piece of paper with a note printed on top of it. That even with a blind eye, without using the advanced technology, you can see the signature in blue ink is underneath the line. What we're saying is that Wells Fargo either lost the original note or more likely destroyed it and digitized, someone along the line digitized it. Instead of using a lost note count, they're trying to get past the self-authenticating documentation language of Florida statutes to avoid the hearsay, the admissibility of the note by providing a forged note. Dr. Benjamin Bird actually had 3 conclusions. The signature of my client was underneath the line. It was actually printed first.
I need to advise you, counsel, you're at 15.
Oh, thank you, Your Honor.
It's still your time. You can keep on using it if you wish.
He also found that Calvin Waltman's signature was also applied to the page first with the note printed over it. And using optical coherence tomography, one can actually determine the chemical composition of the matter on the original documents. He concluded that Linda Tang, the person who signed the other the assignment, that her stamp was composed of ink from a printer instead of ink from an actual stamp. But I'll go ahead and defer to in my time now, Your Honor.
Okay, thank you, counsel. 1 second, please, so I can turn off the machine so that next counsel doesn't start at that time. All right, Mr. Morandi, we are ready, sir, for your presentation.
Thank you. May it please the court. Your Honor, Dean Morandi of Carlton Fields on behalf of the Applee Wells Fargo Bank. I think the court pretty much hit the main issue on the head in terms of the substantive issues that the appellant has raised here, in terms of they are all evidentiary issues that the court, as trier of fact, weighed the evidence and determined adversely to Mr. Campbell. And pretty much with that alone, all 8 of the arguments can be rejected. But I'd like to start with 2 issues that allow the court to affirm without even getting into those evidentiary issues. And the first one is the trial court's ruling on unjust enrichment. If you look at the judgment itself, the court plainly ruled that it found in favor for Wells Fargo an unjust enrichment. And for that reason alone, the foreclosure judgment can be affirmed. And if you go back to the initial brief does not challenge that alternative basis to affirm the final judgment. And for that reason alone, the final judgment can be affirmed.
Well, let me
Now-
ask you this with regard to unjust enrichment. Does the final judgment then reflect an amount of damages? Will the unjust enrichment have a secured interest that permits a foreclosure?
Well, that's ultimately what the trial court found. I'm looking at page 5042 of the record. It goes through unjust enrichment, and then the court finds the defendant has presented insufficient evidence to prove that Wells Fargo would be unjustly enriched by a foreclosure judgment. Also says that Wells Fargo has shown the defendant received a benefit that under the circumstances would be inequitable for the defendant to retain without compensating Wells Fargo. Now, I think I understand Your Honor's point to be that unjust enrichment might not allow for the remedy of foreclosure. But my point here is to say that this is the finding of the trial court. It's a basis to affirm the judgment. Whether it's correct or not is not an issue here. It has to be challenged by the appellant, and it has not been here. So for that reason, that's a basis to affirm.
The failure then to raise the argument waives the issue for appellate review. It's not preserved. Therefore, this aspect of the judgment is required to stand as a matter of law. Is that the argument? Do I understand?
That is the argument, Your Honor. Yes, correct, Your Honor. The other piece to that argument is that because the issue was not raised in the initial brief, it's deemed waived and it cannot be revived through a reply brief. And I think the court is well familiar with that case law. The reason why I raise it is because in the reply brief, part of it's not completely clear, but part of what it appears Mr. Campbell was maintaining is that it can be revived in the reply brief. And I just wanted to make the point that that's incorrect as a matter of Florida law. Mr. Campbell also attempts to get to the merits by suggesting that an express contract exists, so there can't be unjust enrichment. Well, first of all, again, wasn't raised. We don't get to the merits. Second of all, one of Campbell's arguments throughout this case has been to attempt to disclaim the loan documents. Another issue, he suggests in the reply brief that the final judgment is unclear on this. Well, I would direct the court again to the record on this judgment, and I'm looking at 5042. In the record, it's quite clear in terms of what the trial court is ruling on this issue. And finally, in the reply brief, I think part of the argument is to suggest that, well, you can look at all my other 8 issues, and from there you can cobble together an argument to oppose unjust enrichment. Well, that's not the way preservation works. It's not the way raising issues on appeal works. The other point there is the issues being raised in the reply brief are separate and apart from the issues raised in the initial brief. So clearly, you couldn't just cobble together an argument against unjust enrichment. So I wanted to raise that point in saying that because the appellant didn't sufficiently challenge an alternative basis to affirm the judgment can be affirmed for that reason as well. There's another reason why the judgment can be affirmed, which is ratification. Campbell ratified the loan documents, and just here, this issue was not addressed by the trial court, but we're making this as a tipsy coachman argument. Any ground that supports the judgment is a basis for affirmance. Was not raised in the initial brief either. We raised it in our answer brief on ratification, suggesting that because Campbell paid on this loan for 4 years, 3 of which was directly to Wells Fargo, he was on reasonable notice. Because as a sophisticated buyer and a real estate agent, he was on notice as to any issues with regard to the loan documents, and he will be deemed to have ratified those loan documents. In looking at the reply brief, there's absolutely nothing on this issue. The only time you see the words ratification is with regard to the court shouldn't agree with this doctrine because it would send the wrong message, for whatever that means. But that's all there is in the reply brief. We also didn't hear anything on that in counsel's presentation here. So ratification presents yet another basis to affirm the final judgment of foreclosure. Now, I believe either of those 2 issues are dispositive, but I'll briefly mention some of the other issues that were raised. The first issue of which is this hindsight imaging, where the trial court, the argument is apparently that the trial court improperly weighed the evidence and it should have credited the testimony by hindsight imaging. This company that has been around had only been around for 4 years at the time of trial. Their primary division is to analyze gemstones, and they have another division with human tissue analysis. They made 3 findings. And just on its face, those findings seem, I don't want to go so far as to say unbelievable, but definitely to questionability. That there was an actual authentic signature by Stephen Campbell on a piece of paper, and somehow Wells Fargo got a hold of that. And because they didn't have the original note, they used this piece of paper with an original signature on it and created the note around it. Somehow the signature was in just the right place, and that was the conclusion of the hindsight imaging. That's questionable to me. And they made that finding twice with regard to another document that had Watland's signature on it. So on its face, that seems somewhat questionable to me. But either way, let's talk about the other evidence very briefly undermining hindsight's conclusions. He had ignored obvious sources of relevant information, such as that Campbell signed in blue ink, and he testified that the form matches the note that he signed, didn't investigate or seek information from anyone involved at the closing, didn't look at the handwriting pressure, didn't look at the age, storage, or transportation of the documents. Several issues there. There's also issues in relation to bias. Hindsight Imaging paid $50,000 for this, but guess what? They haven't been paid a penny because it's contingent upon Mr. Campbell prevailing and getting the house free and clear. I don't know. Their payment was made by a quitclaim interest in the property. So at this point, they haven't been paid anything. It's contingent on Mr. Campbell winning. The other issue is Bird testified that he found fraud in nearly every set of documents that the company examined. That's somewhat suspect as well. So again, evidence of bias is also an appropriate basis for the trial court to discount that evidence. And then of course, we have the contrary evidence in the case, which is, as the trial court found, Wells Fargo tracked the original loan documents in its system. The system showed that Wells Fargo had these original documents since before this action was filed. And it also showed that the original loan documents were filed with the clerk since 2015, and they've been maintained with the clerk for that entire period of time. As a result, the trial court was well within its discretion as finder of fact to find that testimony not credible. The other issue we've heard in the briefing and we hear today is that there's 3 allonges. I want to correct that language. There are not 3 allonges. There's 1 operative allonge. There are 2 other documents that are inoperative documents. Let's talk about the first allonge. And I use that language only out of just to make it easier to understand, because that's what Mr. Campbell has been calling it. It's a document that happened to be in the loan file. It was produced to Mr. Campbell because it was in the loan file, but it was never an operative allonge. It was not attached to the original complaint, not attached to the amended complaint, not attached to the original note filed with the court, and it was not part of Wells Fargo's case in chief for foreclosure. It's just a document. It was not a legally effective allonge. And of course, the trial court was free to reject whatever inference Campbell sought to draw from that document. Second document is, again, not an allonge, but I'll say second allonge, just so the court understands what I'm referencing in relation to Mr. Campbell's argument. And Mr. Rosen himself correctly noted that this is a nonsensical document. It is a document signed by Mr. Campbell on behalf of WC Mortgage. Obviously, that's not an appropriate document. Obviously, that was a mistake. Testified to that it was a mistake. It is plainly not an operative allonge. It is just a piece of paper with no legal effect to it whatsoever. And then finally, what's been called the third allonge, that is the actual allonge in this case. That is what was attached to the initial complaint. That is what was attached to the amended complaint. And that is what is, of course, attached to the original note that is in the court file. And that was the document that Wells Fargo proceeded to trial on. And at absolute best, there is a question of fact here that the trial court was well within its discretion to find in favor of Wells Fargo on. We also heard some issues with regard to the certificate of possession of original note. And what I just explained with regard to the that there being only one allonge goes into the certificate of possession argument. The argument here is that, well, you had an original, your initial complaint had the note, but it also had that piece of paper that Mr. Campbell signed on WRC on behalf of WC Mortgage, which is by all accounts nonsensical, but the amended complaint doesn't have that document. Well, the testimony is that that document is not any kind of legally enforceable document. It's not anything. It's not an allonge. It's just a piece of paper that has no impact on the enforceability of the note. So it was removed and it does not appear with the amended complaint. For that reason, there's absolutely no reason to go get a new certificate of possession of original note. Nothing has changed with regard to the operative documents. And that's pretty much the end of that argument. That's really all there is to it. And as you'll see with a lot of these arguments, they build on, presupposing that there's fraud, and that's why we get up to 8 issues. Happy to address the issue with regard to the mortgage being properly pled as collateral for the note, but we didn't have any argument by Mr. Rosen on this, so I won't go into that unless the court has any questions. Okay. The fact that the word corporation appears on the allonge, that's supposed to be an argument to say that the note itself is unenforceable. Well, we have testimony by WCR Mortgage's president, Calvin Watland, testifying that the word corporation was there as a Scrivener's error. In other words, it wasn't supposed to be there. He testified to that effect, and for that reason, it doesn't impact the enforceability of the note. It's a Scrivener's error. It doesn't need to be changed. It's something that it's plain that the proper party to the note is Watland Realty Corporation doing business as WRC Mortgage. Now it says WRC Mortgage Corporation instead of just WRC Mortgage. Well, we have the president of the corporation saying that the word corporation shouldn't be there. Yes, Mortgage Corporation was administratively dissolved. It was something that existed at one time, but it wasn't here. That wasn't the proper party to the note here. It was nothing more than a Scrivener's error. And again, the trial court was well within its discretion to agree with that testimony and find in Wells Fargo's favor on that point. That is, for the most part, all of the arguments that have been raised here today. There's a couple more in the brief. We can stand on our brief to the extent the court has any additional questions. If the court has no questions, I will wrap up and say that I think we have numerous bases to affirm the final judgment of foreclosure here, and that is the relief we would request.
Thank you, counsel. I don't see any questions, so let me address the time clock here and change it over so that it works properly for everyone. Mr. Rosen, you have 4 1/4 minutes remaining.
Yes, Your Honor. Thank you. If you can remind me when I have 1 minute left, Your Honor, if you don't mind.
I'll do my best, sir.
Your Honor, the problem I have, if the court allows a mortgage foreclosure based on unjust enrichment and ratification based on the fact that you made payments, therefore you ratify the mortgage, all mortgages would be very quickly taken care of. They can be taken care of in summary judgment. We don't need to go through conditions precedent. We don't need to go through standing. The plaintiff only has to show the homeowner received monies and homeowner made a few payments. Therefore, we win. But this entire 4-day trial could have been avoided if we just came to that conclusion right away. Now, the plaintiff chose not to authenticate the signatures. They chose not to have their own expert testify. All they did was attack our experts. We're not saying that Mr. Campbell didn't sign the original note. Of course, he signed the original note. What we're saying is the plaintiff lost or destroyed the original note. Instead of filing, which should have been proper, a lost note count, they recreated the note and used it fraudulently to overcome the presumption of an authentic note. Therefore, Mr. Burt testified that he's a scientist. He looks at objective facts. He testified the fact that there's no need for me to talk to Mr. Campbell. Asked Mr. Campbell to sign the note. He's a scientist, looks at the objective facts. He used scientific principles that are accepted in the community using optical coherence tomography and hyperspectral imaging, and he reaches conclusions. So a lot of the points raised by opposing counsel, I don't believe are genuine. If you look at
Mr. Rosen, I want to
Yes.
make sure I understand some of the facts here.
Yes, sir.
You have argued that your client did in fact sign a note and a mortgage encumbering the subject real property. Is that correct?
Yes, Your Honor.
And did your client deny the breach by the failure to make payments?
My client withheld payments with dishonor. He specifically sent a certified letter to Wells Fargo explaining his concerns, to which Wells Fargo did not respond to him.
I understand, having read the news media about what Wells Fargo has done in other areas of its business, and I'm certainly not challenging your client's suspicions. My concern is here, as I understand it, we're basically admitting all the allegations except for the formality of having the original note or a lost note claim. Is that what what you're saying, is that these are the technical obstructions to affirmance? Is that correct?
Yes, Your Honor. No one
Okay,
should
I
come.
just want to make sure I got everything philosophically lined up.
Yes, I believe so. Good. No one should be able to come to this court with fake, fraudulent forged documents. The state court should have been very upset after hearing testimony from our experts regarding the authenticity of the note. I'm sorry, give me 1 second. The Doe case. The Doe case cited by the plaintiff, it's incorrect. It doesn't apply in this case because the Doe case stands for the proposition that by failing to challenge or address the alternate ground supporting the final judgment foreclosure, they say that the appeal cannot succeed. In the Doe case, the court stated that in the initial brief, the appellant completely ignored the ruling. Although in its answer brief, she argues at some length in its position, she chose not to file a reply brief addressing that argument. Therefore, of course, as I repeatedly stated in the reply brief, we did address that in the reply brief. Therefore, we don't think we waived any rights to argue unjust enrichment. Unlike Doe, the reply brief specifically addresses the issue being filed in this case. Also, unjust enrichment, Your Honors, is actually an equitable remedy. It should fail upon a showing that an express contract exists. Unjust enrichment should be an alternate to—
You have 1 minute remaining.
That no contract exists. Thank you, Your Honor. Also, the trial court's order doesn't actually state unjust enrichment, only that Wells Fargo has shown that the defendant received a benefit that under the circumstances would be inequitable for the defendant to retain without compensating Wells Fargo. The reply brief cites over and over and over all the different circumstances of this case, which I defer to as to why the plaintiff should be successful in this action. Your Honor, collectively, the appellee fabricated evidence, altered evidence, removed an allonge from the court file, used the same certificate of possession twice to verify different allonges, offered a forged recreation as the original note, possesses a mortgage that failed to create a security interest in the real property. All this is covered, of course, in my brief. They allege Scrivener's error using a fictitious name for corporation, when public records show an additional 64 mortgages using the same name, but there was no Scrivener's error. Yeah, I asked the court, please review the briefs in detail because I know there's a lot more that we can't argue in these few minutes, but I believe that our position is clear and that the plaintiff should not be able to prevail in foreclosure.
Thank you, counsel. Thank you both for your presentation. Let me clear the clock so I don't start the next case improperly. Stay well. We'll see you next time.
Thank you, Your Honors. I appreciate it. Have a good day. Thank you.
Thank you. The next matter to be brought over is Centrala and the Bank of New York Mellon. Okay, I believe that we have everyone present for this matter. Attorney Lundergren, I believe you represent the appellant, and did you wish to reserve time for rebuttal?
Yes, I did, Your Honor. If I could reserve 3 minutes.
3 minutes? Okay, I have made that notation, and we are ready to begin.
Thank you, Your Honor, and good morning to all of you. Amanda Lundergan on behalf of the appellant Suzanne Centrella. May it please the court. The facts of this case are relatively undisputed.
Well, that brings me to my first question. You wanted a hot panel, perhaps, and maybe not this hot that early. My question is whether or not this court has jurisdiction at this moment in time to consider this appeal. This is an appeal from an order entered by, I believe, Judge Hayes, denying the right to contest certain matters because of bankruptcy proceedings. There is yet no final judgment. Most of the cases that were cited and that I've read in this area suggest that this case, this issue has come up in conjunction with the final judgment. So I'm not certain that I can pigeonhole this particular appeal into a non-final appealable order. And as it's not final in the case, because there's not been a final judgment of foreclosure, my concern is, do we have any jurisdiction, the power to do anything on this case? And I know since you filed the appeal, you must have thought so. So I'm going to give you a chance to tell me why.
I do believe that this court does have jurisdiction to hear this issue, and I believe that it is final as to Suzanne Centrella. I would liken it to if the court had officially struck her from the case as a party. She would have the authority to appeal that decision, and that is essentially what the court did when it ruled that she has no ability to participate in the case and struck her answer in its entirety. At that point, the judicial resources were complete as to the defendant, Suzanne Centrella. She was no longer a party or a participant in the case. Therefore, all judicial resources were complete as to her interest. And I think at that point, it did become final to Suzanne Centrella, enabling her to bring that issue before the court, just as if she had been stricken from the case entirely. I hope that answers your
What does
question.
she have on the state of these pleadings? Since there's no final judgment yet either way. But I think, in other words, let me see if I can phrase it. If there was a counterclaim that alleged some sort of equitable relief or entitlement that flowed from conduct subsequent to the foreclosure proceeding, that is the eviction of squatters, the expenditure of funds, then I might be a little bit more concerned about the trial court's exclusion of her from participating in the case. But the only pleadings that I saw in this file are an answer and affirmative defenses to exactly what happened in the foreclosure, the offer to the bankruptcy court.
I'm not sure I quite understand your Honor's question.
If the bankruptcy court and the federal 11th Circuit case, which has been followed, governs, and the trial court is correct as it applies to the relinquishment of ownership of the property, theoretically. If you have a counterclaim or some sort of claim that says, subsequent to this event, my client did A, B, and C, for which we have arguably obtained rights, then I think I might see your complaint that, hey, you can't participate as being an infringement on your right to prosecute that which is subsequent to. But in terms of the universe created by the bankruptcy, I guess that's where I'm having my problem. And I have a second corollary problem for the appellee, and that is, why didn't you go ask the bankruptcy court to reopen the proceeding and do what you should do to get the bankruptcy court to give you the order for the property? There's some federal cases on that point where reopening is permissible. But my concern is only right now, the immediate state of our pleadings. Do we have the jurisdiction to look at it? And I guess you're saying the word unable to participate in any way in the future is overly broad.
No, I think it's conclusive. It concludes her participation in the case. If this was an order on a motion to strike her participation in the case or a motion to dismiss her from the case, if the plaintiff had dismissed her from the case, that would be a conclusion. And I think the analysis as to whether or not something is final always looks at, is there any more judicial resources that will be expended with regards to Suzanne Centrella's defenses, claims, and participation in the case? And it came to a conclusion. It was final as to Suzanne Centrella. She was no longer a participant or a party in this case. And therefore, I think under the analysis of whether or not it's final, it is final. Clearly, the bank didn't challenge whether or not it was final on appeal, and the court has a right to determine that now.
Most orders are interlocutory. This was not, for whatever reason, reduced to a summary judgment on the issue. It's an interlocutory order. And as I understand most interlocutory orders, they are subject to being revisited by the trial court, which argues against it being some sort of final order that we would arguably have jurisdiction over. I mean, I think we're both seeing the concerns, and I don't want to take up 20 minutes on this. You know, if your answer is the same, I've got it. You know, I've got
The
it.
answer is the same, Your Honor. I think it concluded the litigation as to a party, and that party has a right to appeal it because it's final as to her. Getting back to Your Honor to the facts of the case, as I stated, I think they're largely undisputed, but I think they're very important to the analysis of the issues on appeal. 9 years prior to this foreclosure case, Ms. Centrella files a Chapter 13 bankruptcy, indicates an intent at the time to surrender to Bank of America Home Loans, not a current plaintiff. She then moves out of the property and does what, under any other circumstances, the bank would laud her for doing. She contacts them, says, I've moved out, you can have the property, and she moves on with her life. 6 years later, she gets contacted from the city and says, well, you actually still own the property. The property is now overrun with squatters and is dilapidated. She becomes concerned with her liability. If someone were to get hurt on the property, there are crimes being committed on the property. And so she takes possession back of the property and spends $60,000 removing the squatters from the property and fixing the dilapidated condition of the property. Fast forward, the bank files its foreclosure action and then allows her to participate in the case for 18 months, saying nothing about the bankruptcy proceedings. She conducts discovery, files motions, files answers with the defenses, and it's not until they filed the motion for protective order as to a certain set of discovery that for the first time they raised this issue of judicial estoppel based on the bankruptcy. That's followed up with the motion that resulted in this appeal, which is the motion for judicial estoppel under 1.140F. The court ultimately granted that motion, despite the fact the bank had not filed any averment or defenses to the defendant's defenses. And in doing so, they struck her from the case, struck her answer, and opined that she had lost title upon filing of the bankruptcy and therefore had no reason to take back possession of the property. But for 4 reasons, this court should treat this as a final appeal and reverse the decision of the lower court. The first is that the vehicle by which the plaintiff brought their motion, 1.140, simply doesn't apply in these circumstances. It was based upon judicial estoppel, and I think we would all agree that judicial estoppel is a defense, and the defense is waived if it's not raised. For whatever reason, the bank never filed any defenses to the defenses that were raised by Ms. Centrella, and therefore it was waived. Next, 1.140F doesn't provide a mechanism for dismissing or striking pleadings on the basis of judicial estoppel. It's very clear and very limited on the grounds with which the court can strike pleadings. It lists them as being redundant, being immaterial, being impertinent, or being scandalous, or otherwise wholly irrelevant. The bank wants to now focus on the prong of wholly irrelevant, but uses a circular argument to do so. They're wholly irrelevant because she should be judicially stopped, and she's judicially stopped because they're wholly irrelevant. And that simply doesn't get them where they need to go. But even if this court were to overlook the fact that it was not pled and therefore waived, and even if this court were to overlook the fact that it's not appropriate under 1.440, instead it should have been a summary judgment, as Judge Casanova pointed out, they simply didn't meet the 5 prongs.
I wasn't making a ruling of law on that. I was making a comparison.
And I'll
And
get to
remember
that.
that's
Why
only
that would
one
have been.
and even if it was my view, it's only one.
They have 5 prongs they had to prove for judicial estoppel, and they didn't meet any of them. The first is that the party against whom estoppel is sought must have had a clearly inconsistent or conflicting position. Ms. Centrella has never taken an inconsistent position. She's elected to surrender the property to Bank of America, and nothing in the record suggests otherwise that she hasn't done that. Secondly, the position assumed in the former proceeding must have been successfully maintained. Well, there's a big question of fact here as to that. What the bank asked the court to take judicial notice of was her initial bankruptcy filings, which did include an intent to surrender the property to Bank of America. But on closer examination, on the confirmed plan Exhibit A, which lists the properties which were surrendered to creditors, this property is not included. So there's a big question there as to whether or not she was actually successful in the bankruptcy, and that's never been decided by the court. Third, the proceedings both have to involve the same parties, which we don't have here. And 4 and 5, the party seeking relief must have been misled by the former position, and the party seeking estoppel must have changed their position. Nothing in the plaintiff's motion for judicial estoppel made an allegation as to either of those prongs. And so the motion should not have been granted by the court. It's not an appropriate motion. What it really was is a motion for summary judgment. But because it was really should have been a motion for summary judgment, I had no sworn evidence before the court. The only sworn evidence before the court was a verified statement of Ms. Centrella. And so at best, the motion should have been denied because plaintiff didn't meet their burden. And at worst, there were issues of fact that should have precluded granting a judgment on that particular issue. The second reason why the lower court should be reversed is because the doctrine of laches applies. Laches requires two things: lack of diligence by a party against whom the defense is asserted. I don't think anyone can say there was a lack of diligence here when 9 years passes between when a defendant not only makes it available to the bank to foreclose, but notifies them that she's vacated the property, and they sit
Do we
on
have
their.
a trial court order on the issue of laches?
We don't, Your Honor. The only
How
order
do
that
we
we
then, how
have,
does this court then review it?
it was argued as part of our opposition to the motion that's on appeal. It was preserved in her.
So the argument
sworn
is that the
statement.
trial court should have taken evidence on the theory of laches and then made a
Absolutely.
determination.
Absolutely. They were going to take counsel's unsworn statements on the issue of judicial estoppel. They should have taken the defendant's sworn statements on the issue of laches. The second prong of laches is that there was prejudice to the party who's asserting it. Clearly, there was prejudice here. They held her hostage for 9 years, dragging her back into this property because of a fear that she was going to be liable if somebody get hurt or injured, or she'd be fined by the city for the condition of the property. And that's really an unreasonable request for somebody who has discharged this in bankruptcy, indicated intent to surrender, and done everything they can to get out of the way of the bank, to drag her back into the tune of $60,000 to protect herself, is really a prejudice. And that's the prong that the trial court really got wrong. The trial court said, well, there can't be any prejudice here because as soon as you file the bankruptcy, title transferred. And admittedly, the bank has admitted in their answer brief that was a wrong statement. The title did not change hands, and it does not change hands until the bank finishes its foreclosure. And we only have to look at the Corriganis court, who, setting aside that this case was a 9-year delay and a 5-year delay, the court ruled that the bank had slept on its rights and that the doctrine of laches applied. What's very ironic about this issue is in response to us raising laches, they say, well, you didn't raise laches as an affirmative defense. Setting aside that they didn't raise judicial estoppel as a defense to our defenses, this issue was not raised as an affirmative defense to the underlying action, the foreclosure. Ms. Centrella is not seeking to prevent them from filing a foreclosure on the theory of laches. She's simply raising it in response to the bank using judicial estoppel as a sword and trying to prevent her from participating in the case and saying, you're not the bank that I surrendered the property to. There's a standing issue here. And so it would not have been raised as a defense to the complaint, but only became a relevant defense when they raised their motion for judicial estoppel. Third, in order to come to the conclusion that the lower court reached, we necessarily have to retroactively apply a very concrete, strict definition of surrender that didn't exist for 6 years until 6 years after the notice of intent to surrender was filed. In fact, at the time that Ms. Centrella indicated an intent to surrender, that definition was not defined in the bankruptcy code, and it was subject to multiple interpretations depending on which county you practice in and which litigator you spoke with. It could mean anything from dissolving the automatic stay, but leaving you free to contest things like standing in the trial court, to reverting it back to the bankruptcy trustee, who then makes a determination of, am I going to sell this property or am I going to give it back to the homeowner? It was not until what they've called the landmark decision of Fiala in 2016 that the court applied this very strict definition to the term of surrender in the context of a bankruptcy. And in fact, courts in 2 different proceedings have elected not to apply this definition to bankruptcies that were filed significantly before that landmark decision, and that's in re Townsend and in re Ayala. And fourth, Your Honor, the promise to surrender to one entity has never been extended to include a promise to surrender to just anyone. If that were the case, they would invite anyone, including somebody, a thief, to come forward on a property that has been surrendered and file bankruptcy, knowing that the debtor has their hands tied and cannot raise this issue of standing. The court has not extended that to that extreme, and it would be nonsensical to do so. And so for all of these reasons, the court should reverse the lower court's final decision and allow Ms. Centrella to participate in the underlying foreclosure.
Thank you, counsel, and you're well in advance of your 17-minute warning. You're at 14 and a half. Okay, I'll make the notation here and I'll stop the clock. And okay. Mr. Ruff, I think we're ready to hear your presentation, sir.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, my name is Michael Ruff. I'm with the Paget Law Group, representing the appellee. Just very briefly,
Mr. Ruff, when the debtor in bankruptcy surrenders the property, do they not surrender it to the trustee and to the owner of the property, the mortgage holder?
Your Honor, it's a surrender to both creditor, to the trustee and to the trustee first. And if the trustee does not do anything with it, the trustee abandons it, then it is to the creditor.
Okay, and
but-
so why isn't the creditor getting an order from the bankruptcy court just saying that none of the processes at section 521 has been completed, the surrender now goes to the creditor? I mean,
Your
the
Honor,
bankruptcy court has the ability to reopen their case, and this has nothing to impact any rights of any other party. It's simply a matter of transferring the legal interest to your client. Why isn't that something can be done by the bankruptcy court?
Sure, Your Honor. I guess as an initial point to that, surrender does not mean transfer of title. So to briefly to Ms. Lundergan's.
It would certainly enhance your legal interest to have the order
Well,
from the
absolutely.
bankruptcy
Yes,
court.
sir. Yes, sir. But surrender means simply that they can no longer contest the foreclosure by any subsequent creditors. In order to get title, foreclosure must still happen. Now, what has happened in the case law is, frankly, both things are covered. There are ample cases, the Townsend case, the Ayala case, the Ms. Lundergan cites too, where foreclosing lenders do indeed go back to the bankruptcy court and seek an order. And that was the case in the Fila case. I don't know if I'm pronouncing that correctly, Fila and the Metzler case, where the foreclosing lender is seeking a reopening of the bankruptcy case for the bankruptcy court to enforce the surrender and to issue an order saying that the borrower, the debtor, is stopped from contesting the foreclosure further in the state court. But there's also plenty of state court cases from this very district, the Lewis v. Inova case, the BMG case, the Fisher case, where this court, the Second District Court of Appeal, has stated that estoppel and a defendant's, a borrower's ability to contest a foreclosure in the state court is precluded if they indeed have surrendered. Now, the difference with Fisher is there was a little bit stricter standard in terms of Fisher, the court declined to enforce that because it was not clear as to the surrender. But in the Inova case and the BMG case, it was clear. Our position would be that it is clear in this instance that there was surrender. There was an admission of surrender in the initial brief.
One of the concerns I have, and obviously I'm not a bankruptcy practitioner, although I did have the pleasure of appearing before Judge Pasquet on several occasions. The Fila opinion cited, if I recall correctly, with approval, a middle district opinion called Guerra. And in that case, Guerra, there was talk about a lapse of time, inconsistent positions, and they would leave that then in terms of judicial estoppel for the surrender to the state court. If that's a correct interpretation of the law, can the trial judge here prohibit the contesting of acts that are not related to surrender? That is a total, I forget the word counsel for the appellant used, but a total, you can't do anything. And it seems that maybe, FIA, by citing this case with approval, says where time has gone by, lapses are in there, there's inconsistent statements, perhaps the debtor can challenge in state courts because that decision out of the middle district says it is left to the state courts. And again, I'm not a bankruptcy practitioner, and I'm trying to make sense of these rules that I don't use every day. And I want to make sure I'm consistent on behalf of the court. So does that mean the trial judge erred? If that decision is correct because of time and inconsistent positions, they should be allowed?
Your Honor, Your Honor, I to a certain degree, I don't disagree with what you're saying. The case law is to a certain degree all over the place. I would also, as the same point that Guerra makes, the Couragenis case that Ms. Lundergan brought up, that was another instance where a foreclosing lender, if I recall correctly, tried to get a bankruptcy court to reopen a bankruptcy order in order to enforce. The bankruptcy court declined, but then they cited to
Was that the one about 5 years and debtor's husband?
Correct. And
okay, good, because I didn't remember the name of it. I just remember I saw it.
The Couragenis case is a bankruptcy court case, a bankruptcy court order, where they declined to reopen, and the bankruptcy court cited to laches. But importantly, in Karagenis, and again, I'm paraphrasing here, I'm not quoting, so forgive me. The Karagenis case, the bankruptcy court was very careful to say that the laches prohibits the bankruptcy court from being reopened, but and specifically the bankruptcy, but also specifically that the bankruptcy court cannot exercise jurisdiction over the state court. The Karagenis court, the bankruptcy court, then goes on to state or suggest, excuse me, and again I'm paraphrasing. They suggest the debtor could still challenge standing, but the borrower does not get a free pass either. And this is a quote from.
You can't have your cake and eat it too.
Exactly, Your Honor.
Yeah, I saw the quote.
Yes, sir. She could be confronted in brackets in the state court.
Here's my concern reading from a 2018 case out of the Orlando division called McHale. When a debtor says he is going to surrender his home and then continues to fight a foreclosure action, in most cases, the appropriate remedy is for the bankruptcy court to squelch the debtor's defenses. And that's why I kind of prompted some of my questions. Is this something that should be handled by reopening the bankruptcy case, let them determine surrender, and then the state court applies under supremacy or whatever the bankruptcy court rulings?
Your Honor, I would suggest that that's one way to do it.
Okay,
and like I said,
but it's not mandatory, be your argument.
I believe it's not mandatory. The Lewis case and the B&G case, both from this district court of appeal, there was no indication in my read of the cases that there was an order from the bankruptcy court. It was in the trial court. The trial court had said that estoppel applies. Well,
a lot of times, when we start our analysis, we start with the then existing cases, and that would have been FIA, Judge Pryor's decision. Correct. For the panel. And obviously the federal courts generate interpretive stuff that is subsequent to that is now being brought to our attention. And so we have to figure out whether or not we are going to carve anything out, follow, or whatever. And that's what's prompted some of my questions. And I appreciate both counsel bearing with me as I attempt to learn some degree of bankruptcy law and apply it to Florida proceedings.
Yes, sir.
Mr. Ruff, let me ask you this. So you have talked about the surrender and how Ms. Centralis shouldn't be able to participate. I'd like to hear what your position is to what Ms. Lundergan was saying with regard to her necessity to come back and get involved, not necessarily fighting the foreclosure aspects or whether she should get title, but when you've got a code enforcement board who's coming after them and the bank is sitting there just expecting someone else to do it because they're not the party of interest. How is it that your client should behave in that situation versus the interest of the person who's still the record title holder?
Sure. And Your Honor, I think if I'm understanding correctly, what you're essentially talking is a policy argument.
No, I'm asking you from the law, what is it that you say? Is it your position that under the law, the way it is, that the surrender is the surrender, and Ms. Lundergan's argument is for naught, her client is just out of it? I saw in your brief, you argued she could have moved back in. She could have continued living there. But if somebody is living someplace and it needs a new roof that costs $20,000, but they know a foreclosure could start any day, that they're not likely to do that. How long is it your position that that doesn't matter? They shouldn't be able to be a party to even make that claim in a subsequent foreclosure action, no matter how long the bank waits.
Your Honor, I mean, certainly sympathetic to her arguments, just as a human being, but under the law, the surrender does not transfer title. She, just as she moved out to allow the bank does not get title, a creditor does not get title from surrender. A separate action must be filed, the foreclosure action. Right. Miss Centrala moved out purportedly to allow the bank to take over, but the bank can't simply take over. The bank is not entitled. The bank does not have a legal interest in the property other than as a lien holder, unless and until they file foreclosure.
You're arguing though that surrender should keep her from participating. But if the facts of the situation as they arise give credence to the fact that she should be able to participate because the bank's inaction, latches or whatever, has caused her to have to suffer additional damages based on her having to go out of pocket, her having to evict somebody. Why shouldn't they be allowed to be a party to make those arguments to the trial court?
And if I may, Your Honor, 2 points on that. The first one is the trial court did address that in its ruling. I don't recall the exact page, but it's the end of the transcript of the trial. It's in the record. And the judge essentially said, I believe that some of this may or should have been a separate action, a counterclaim, et cetera, for and I'm going from memory here, but I believe for set off or a separate action for damages for what she paid out because of the alleged inaction by the bank.
So
but
if
the
that's
second
the
point,
case, before you go there, then under your argument that surrender is surrender and she shouldn't be able to participate, you're now saying, had there been a counterclaim, you would agree that they would be able to participate.
I think that's what the trial court was saying, was suggesting, if you will. But
Well, then wouldn't the remedy have been to direct her to file a counterclaim? I mean, you throw somebody out of court because you think they sought the wrong remedy. Isn't the answer, if you think someone's seeking the wrong remedy, to treat them as if they've sought the right remedy or direct them to file the appropriate pleading, not exclude them from court?
Well, I think the court did suggest that as regards Ms. Centrala. I don't know.
How's she going to do that now?
She could certainly move the court to do same. But I would also suggest, as far as the amount of time that has passed, this court in the BMG case spoke specifically as to, and citing the Cohn brothers case, that there is no requirement that a bank move at the will of any third party, including a borrower, in order to move up the timetable for foreclosure of its foreclosure case. The bank can elect for its own when to choose to enforce its lien, when to file a foreclosure. That's this court's BMG case, citing to the Cohn brothers case. So
you're suggesting that our prior decisions should bind us, that under all circumstances, no matter how long a bank waits, the bank waits 15 years, somebody's got to go put a new roof on it, they get liens from their local code enforcement that can be enforced against their other properties, serve as a judgment. None of that matters. The bank gets 100% carte blanche to decide when they want to go forward.
No, nothing to suggest that there's carte blanche by any means. But again, this is a court, the lower court, foreclosure is a court sitting in equity. And what you have to look at are the balance of the equities. And for example, one of the issues here is that
if you're balancing the equities, how are they going to balance the equities if one of the parties isn't even allowed to be there?
Well, Your Honor, my client, the appellee here, should have been a party to the original bankruptcy. They should have been listed as a creditor. They were not. There was an assignment of mortgage recorded in the public records that indicated the appellee as the assignee of the mortgage, and that assignment of mortgage also transferred the note to the appellee, recorded in the public records in 2009. The bankruptcy was filed in 2011. Under 695.11, the recording of any document in the public records is notice to all persons of whatever interest that might be. So Ms. Centrala in her bankruptcy in 2011 was represented by counsel. For whatever reason, they listed, and there's not any statement in the record as to why they named BAC America Home Loans, and I may get the name wrong here, forgive me, but no reason given in the record as to why they named that particular entity as the creditor. But the simple fact is they should have named the appellee. The appellee had a valid legal interest in the property by virtue of the assignment of mortgage, as well as the note, 2 years before bankruptcy was filed. So to balance the equities, Your Honor, I would suggest it's not equitable that Ms. Centrala gets to make a mistake, whether inadvertent or deliberate, not name the proper party as a creditor to the bankruptcy. And then when the party that should have been named comes forward in their foreclosure 6 years later and tries to say you surrender the property, you were stopped, they bring up the argument, this is the same party argument, that, well, you're not the party we surrendered to, therefore you don't get to make that argument. The argument that I named, and if, again, paraphrasing here, but I named the wrong party, I did not name the right party, but that doesn't matter because you weren't named, you don't get to bring up these bankruptcy issues. And that would also bring into the judicial estoppel rules, not rules, but the guidelines, one of which being the mutuality of parties requirement for judicial estoppel, but the Bloomberg exception to the mutuality of parties, which is the exception that says that they had to be the same party under special circumstances. So this is the case where
let me phrase it to you, Mr. Ruff, as I phrased it to counsel for the appellant. It would seem, and this ties into what Judge Stargell was bringing up and Judge Kelly, that had there been an opportunity to plead, for a resulting trust or equitable lien or whatever on conduct passing, that FIAA would not bar their participation in the case because it's only as to the turnover of the property, that which they promised to do in bankruptcy, the surrender. And this is conduct subsequent to. And my concern is I read Judge Hayes's order. It says it's a final order to has her ability to litigate in this case. And then the next paragraph 3 is interesting. It says the affirmative defenses and the jury trial demand are stricken and defendant is precluded from contesting the plaintiff's foreclosure action. If that would then suggest that her answer still stands because it only strikes the affirmative defenses and jury demand. So her answer is still there.
That's how I would read it, Your Honor.
So that would mean she still is a party and could seek to amend her pleadings to assert whatever latches argument or anything else like that. And that would then, I guess, circle me back to whether or not this is really, in fact, a final order, despite its claim to be a final order. I'm concerned because I think FIAA doesn't answer every permutation that can happen in terms of, as Judge Stargell pointed out, you wait 4 or 5 years, rightly or wrongly, not your fault, nobody's fault, but something may happen that impacts the appellant's chance to be heard. Because if appellant is correct that they improved the property and they're giving an award, maybe that offsets the amount of damages due, and that may, in fact, the ability to redeem at a foreclosure sale. I mean, there's a lot of permutations here that at this stage we haven't got to, but you can see them over the horizon.
Sure, and Your Honor, and I understand the what you're saying, Your Honor, and what the point the court's making. But again, I would go back to the whole issue of surrender does not mean transfer of title. There's no requirement that they abandon the property. There's no requirement they move out. He chose to do that. That was a volunteer. When, as the initial brief stated, when she found out that she was still entitled. Well, she is entitled. That's the surrender. Bankruptcy does not convey title. So she was entitled from the get-go, and that's the whole reason the foreclosure case is filed. So the aspect of she moved out, she moved back in, she has $60,000 in damages, et cetera. The same argument can be made conversely, which I did in my answer brief, that there was no requirement she do that. This was a volunteer. She could have stayed there, and she got the benefit of our complaint alleged that no payments had been made, and all subsequent payments that payments were not being made, and to my knowledge, they still haven't been made. Your Honor, how much time do I have left?
You're at 19:20. But I'm going to give you an extra 2 minutes since we have been rather, what's the phrase from the old movie, vigorous in our questioning. I think that was the second Zorro movie as a dancer. It's quite vigorous.
I like being busy more so than otherwise. I get nervous when the court's silent.
Yeah.
So we're proving that we're really engaged on this case.
Yes, sir. If I may, just to briefly, because I do have limited time, just to sum up. I would point again we didn't talk about it much, but that aspect of the assignment of mortgage, assigning the mortgage and note both being of record 2 years before filing bankruptcy, that is critical. That is important. By virtue of the Chapter 695 Florida statutes, Ms. Centrala was on notice. She was represented by counsel in the bankruptcy. To say again, to get to your honor's point, if can't have your cake and eat it too, that's what they're trying to do here. They didn't name us in the bankruptcy. They should have. And now one of their arguments is you weren't a creditor, you weren't listed, therefore you can't make this argument.
And it's up to the debtor to list the people on the schedules, is my recollection.
Correct. To my knowledge, the appellee was not involved in the bankruptcy whatsoever because they weren't listed as a creditor. If you look at the list of creditors, the appellee is not listed. As to again, latches here does not apply for the same reasons. The bank can exercise on its own discretion when to file its foreclosure action. That's per this court's BMG case, citing to Cohn Brothers. The Couragenis case did find that latches applies, but that's in the context of the court coming back, the foreclosing lender coming back to the bankruptcy court to try to reopen. The bankruptcy court said latches applies because it's been too long since the bankruptcy court has been closed. Your more appropriate remedy is to, it says estoppel is not, you can't plead estoppel in the first court. That would be the bankruptcy court. Estoppel must be pled in the second court, the foreclosure court. That's one thing that Couragenis said. And so that's what we did here. That's what the Lewis case did. That's what the BMG case did, was pleading the estoppel aspect in the second court, the state court, based on what the bankruptcy court had previously decided, i.e. the surrender.
Well, counsel, we're at the extended time, so why don't you take 30 seconds to give us your final close?
Thank you, Your Honor. Just very briefly, as to, and I do appreciate the extra time. As to and this is really just to clean things up. I mentioned this in my answer brief. When the judge in the hearing talked about transfer title, I think we made it clear in our answer brief as well as here today that surrender does not transfer title. I think that was a slip of the tongue by the trial judge, the hearing judge. The proper action when surrender, if it had been a transfer title, then foreclosure wouldn't be necessary. I mean, the court case law is clear that foreclosure must be had after surrender. And thank you for the court's time.
Thank you, counsel. Thank you for hanging in there with us. Appreciate it.
Yes, sir.
Counsel, we're going to return back to the appellant. Your mic is muted, so you may want to unmute it before you start. Let me fix the clock. And you stopped at 14.5, so that would normally give you 4.5 minutes if my math is good. And I don't warrant that in any way. Since I gave counsel an extra 2, you'll have the same amount of time.
Thank you, Your Honor. And I'm only going to try to make 4 brief points, and I'll leave some time if the court has any follow-up questions. In no particular order, with regards to the assignment, one of the few things I heard counsel say that we can agree to is the assignment is important. The assignment is important, and it was the basis for fighting the foreclosure on the affirmative defense of standing. Counsel's testimony that the assignment is valid or legally enforceable is not evidence before the court, and that should have been heard and vetted by the court in the underlying substantive merits. There's no evidence before the court as to who was the owner at the time that she filed the bankruptcy, whether Bank of America stayed on as a servicer, whether the plaintiff in this case was aware of the underlying bankruptcy. Those are all facts that are not before the court. And so counsel's testimony doesn't fill in those gaps. With regards to alluding for the first time that the defendant could somehow go back and assert potentially counterclaims or additional arguments, that flies in the face of paragraph 2 of the order, which says that the court finds defendant Suzanne Centrella is hereby precluded from further litigating in the pending proceeding in any manner. That's conclusive. That doesn't leave the door open for coming in and filing counterclaims, and I'm sure we'd get a motion for sanctions if we had done that after this order was entered. So there's no question that the door was completely closed for Suzanne Centrella contesting the foreclosure in any manner. Next, Your Honor, with regards to the issue of the prejudice, counsel seems to indicate that the bank can just sit on their rights, potentially sit on their rights forever. But that doesn't come without the risk that at some point, as Couragenis said, they set the bar at 5 years. At 5 years, you've sat on your rights enough where there is some sort of latches here. I'm fearful that if the court were to rule today that we should go back to the court and try to reopen the bankruptcy, that if the bankruptcy court declines to do that, Ms. Centrella has no remedy at law to overturn this particular order. And because of the amount of time that has passed, the bank never did that, and I'm fearful that the court would choose not to do that. But there has clearly been prejudice to Ms. Centrella. There is no question that when a debtor goes into the bankruptcy court and chooses to surrender a property, it's because they no longer want the financial risk and responsibility of that property. And the bank held her hostage for 9 years, even though she did everything. She would have been lauded for her actions. She contacted, said, I've moved out, here it is, I'm getting out of your way, file your foreclosure. But they took the risk of sitting on their rights for 9 years, forcing her to respond to code enforcement, forcing her to remove squatters, forcing her to fix the property so that she didn't get sued for a property that she wanted to get rid of 9 years prior. So there's no question here that there was prejudice. The lower court completely erred in finding that the property transferred upon filing the bankruptcy, and therefore there could not have been prejudice. All of these issues merit reversal. They should have been vetted by the trial court. And clearly, if the wrong entity comes forward to try to foreclose a property, the court should and could have heard this issue on the issue of standing. She did surrender to Bank of America, but if a different entity comes along and there is a reasonable belief to believe that that party does not have standing, that's an issue that the court should want to hear. So for all these reasons, we would ask that the court reverse the lower court's decision.
My concern before we let you go is I look at this order that you were citing, and indeed in paragraph 2, the trial court order says that the defendant is hereby precluded from further litigating in the pending proceeding in any manner due to her bankruptcy. Now, the bankruptcy is arguably inferentially from that is a question of who is entitled to have title vested in them through a foreclosure proceeding. Is it appropriate us to interpret the court's order saying that all this has to do is with the ability to surrender the property and not, because it doesn't strike the answer in paragraph 3, just affirmative defenses, and not amounts due?
I don't know how the I don't know under the
nobody wrote it and told me. It's subject to,
how
is that an ambiguity, latent or patent? I don't know what.
I don't think the order is ambiguous at all. I think the court intended that Suzanne Centrella shall have no participation in the case. To say that, well, she can't have defenses, but she can have an answer, I don't know how we can interpret that as that would still be participation in the case. And so unless the court's willing to vacate this and provide some sort of instruction to the lower court, to me, this order is not ambiguous. It doesn't leave any door open. And I'm not willing to risk getting sanctioned by trying to go back to the court and raise a counterclaim when they told me I cannot participate in this case.
Well, I know the court did not strike the answer, and just the affirmative defenses and the demand for a jury trial. And I'll have to go back through the pleadings again to see what the affirmative defense is related to see if interpretively, I can make the text work, because it may be one thing of what we intended and another thing what we actually did.
Yeah.
But I thank you for your responses as well. It's been an interesting time, and I will let you know, counsel, that long time ago, I appeared as an advocate before Judge Hayes. So that's how old I am. He was a county court judge at the time, and then an acting circuit judge. So he and I have been around for a while as some of our people. So I know exactly who Judge Hayes is, and I think the world of him. But our job is something else here. And I thank you for bearing with us and all, because this is an interesting intersection of bankruptcy law and the right to litigate in the state courts. I thank you all, and please be safe, and we will see you next time.
Thank you, Your Honors.
Thank you very much, Your Honors. Y'all have a great day.
You too. Okay, the third case is Bonini. If you'll let those people come over. All righty. Need one more. Do we have Attorney Henny coming over? Yes, we do. Okay, good. Don't worry, Attorney Henny, your mic, so you're muted, so whatever you were saying, we didn't get to hear. All right. Sometimes I should remember to mute my microphone too. All right, Attorney Lawton, how much time would you like to reserve for rebuttal?
5 minutes, please.
Okay, I will be your timekeeper, and I will do my best to let you know when you arrive at that point. We
Thank
are
you.
ready to begin, and you may proceed, counsel.
Thank you. Good morning. May it please the court. I'm Lindsay Lawton, here on behalf of Dr. Lionel Vasco Bonini, the former husband in this family law appeal. My co-counsel, Michael Brownlee, is observing remotely. This case is an appeal from an order modifying alimony on Dr. Bonini, the former husband's petition. The trial court properly found that alimony was subject to modification in this case, as the circumstances had changed. The petition for modification came 18 years after the final judgment, and the former wife's financial circumstances had substantially improved, making the issue before the trial court what the former wife's actual need for alimony is at the present time. Even though the trial court did modify the alimony, the trial court made 3 errors in determining the amount of the alimony. First, the trial court failed to use the required methodology under section 61.08 to determine the amount. Second, the court failed to impute income from available sources. And third, the court made a finding concerning the party's lifestyle during the marriage that is not supported by competent substantial evidence and that places an overemphasis on that factor at this stage of the litigation. So getting now specifically into issue 1, section 61.08 requires a trial court to base any determination of alimony on the payee spouse's actual needs, and it requires the court to make specific findings on the list of factors that's included there. And this court has held that these requirements do apply in modification proceedings. And also this court has held that any award of alimony that exceeds the payee spouse's actual need is an abuse of discretion. So again, the statutory language is actual need, and there's some specific factors that were especially important in this case that the trial court's ruling and order didn't adequately address. And that's, of course, all sources of income available to either party. And additionally, the trial court didn't go through the evidence and determine what represented an actual need as opposed to just generally what the former wife's expenditures are. So instead of applying the statutorily required methodology, the trial court used a different methodology, which was to take the $6,000 of alimony that was awarded originally in 2002 and to subtract $600 from that. Now, the problem is that that method had no correlation to the statutory factors. The $600, Judge, you're on mute.
Yeah, thank you. You know, I don't know that I agree with that characterization because she needed that 600 in the past and then she didn't need it. So the trial court took it out. What's wrong with that?
Well, the problem is that when the trial court decides to modify alimony, it has to be based on the current need. And so the 600.
Okay, and she didn't need that anymore.
Correct. Correct, Your Honor. She didn't need the $600 anymore that she was using in 2018 for her health insurance expense, but there's also a lot of other money that she didn't need too, including the $1,600 that she was paying in 2002 for her mortgage payment that she no longer has, the money that she was paying in 2002 to support her minor child that she no longer has to support because the child is now an adult.
Did she get child support for that?
She did. She got $900 worth of child support for that, but of course she also had her own expenditures above that child support to support the child back then. At least her financial affidavit in 2002 showed that what she was paying to support the minor child was more than $900, which was what the child support was. So the problem is that too, when the $6,000 was ordered in 2002, it didn't include a $600 health insurance payment. And we know that because we can look at the financial affidavits and see that that $600 is not what her health insurance payment was in 2002. That $600 was what her health insurance payment had become in 2018. But, you know, in addition to her health insurance payment changing in 2018, a bunch of other factors had changed too, which weren't addressed by the trial court. And those include some of the things I just mentioned, like the mortgage payment, the fact that the minor child had become an adult, the fact that the former wife had inherited an apartment in Florence, Italy, that she is able to rent out for income, and a variety of other factors. And the other thing here is what the trial court found was that the former wife's need for alimony was her need meaning what her expenses are after you take away her actual current income. The amount the trial court came up with was $5,124. And that number was not truly based on need, but based on what all of her expenses are, whether they're needs or wants or discretionary or what have you. But even still, the trial court did not award $5,124 in alimony. The trial court awarded $5,400. And the reasoning for not awarding the $5,124 was that the former wife has, unexpected expenses like we all have, with household repairs and anything that comes up in life. And then the problem with using that as a basis to award more than $5,124 is that it gave no consideration to the fact that the former wife has a substantial amount of money in savings. And so instead of requiring the former wife to rely on her savings to deal with any unexpected expenses, the trial court gave that responsibility to the former husband. And again, that's just not what the statute allows. The statute requires alimony to be based on actual need and to be based on a careful examination of the evidence as it relates to all the factors. And of course, the case law says, and when you do this, when the trial court does this, it has to be sure that there's no savings component of alimony. So the trial court can't protect the wife's savings at the former husband's expense. That is contrary to the Mallard case and just to the statutory language that says all assets and available sources of income must be considered. And so if there are no more questions about issue one, I'll move on to issue two, which is about imputing income. So we know here that the case law and the statute expects an imputation of income from available sources. The statute says the trial court must consider all available sources of income, including income that can be generated from assets that can be invested. And the case law, specifically this court's case in Sharon, specifically says a court is required to impute income for earnings that can reasonably be projected based on liquid assets awarded as part of property division. In this case, the trial court awarded $0 or imputed $0 of income, even though the former wife has two substantial sources of income that can be earned on assets. And those two sources are...
The trial court considered the former husband's expert witness testimony about the 5% and rejected it as unreasonable. So aren't you asking us to reweigh that conclusion?
No, Your Honor. It's correct that the trial court did look at that evidence and reject it as unreasonable, but I'm not asking you to reweigh because the case law says that a trial court cannot simply reject undisputed evidence, particularly from an expert, as unreasonable without any explanation. In this case, the Ms. Gamble gave an amount based on solid reasoning and evidence, which is that 5% is the rate of return that can be expected on investment in Florida bonds. There was no evidence to refute that. There was only the suggestion that maybe there's a lower amount that can be earned if it was invested even more conservatively than investing in Florida bonds, which Ms. Gamble testified without dispute was a conservative safe investment. And the case law does say, as I've explained in the brief, if the trial court is going to reject undisputed evidence, it at least needs to give some rationale. Now here, of course, the trial court said it was unreasonable, but that isn't really a rationale when there's no reason in the record to believe that it's unreasonable. And the other thing is, what is clear here is the former wife has $118,000 in non-IRA funds that can be invested. The former wife presented evidence that the former husband presented evidence that the former wife could get $492 in interest income every month based on that 5% figure. The trial court rejected that, but in so doing, the trial court ended up awarding or imputing $0. And the case law says you have to impute something. There was evidence presented for what would be a reasonable amount. There was no evidence presented for any alternative. And so it seems to me the trial court needed to accept the evidence here that wasn't disputed in order to honor the requirement of case law that you have to impute something. Or even if the trial court wanted, the former wife's counsel offered another option, but it wasn't supported by any evidence. But the trial court didn't even accept that figure. And again, just awarded $0. And then turning now to the IRA funds. Again, the trial court awarded nothing, imputed no income for the IRA. based on the reasoning that there wasn't any evidence that she could withdraw without penalty. Well, that was really an issue that was sort of implicit through Gamble's testimony. It was never disputed that she could withdraw these funds without penalty. The real issue is whether she can withdraw these funds without diminishing what she received in the equitable distribution. That is what the case law requires, and that's what the statute requires. And again, this argument is based on the principles that the statute requires you to consider all assets that can be used to generate investment income. The statute, and especially the case law, says that retirement funds are fair game when it comes to imputing income. And that's because the legislature in section 61.08 made clear that it expects a former spouse who is seeking alimony to rely on her own or his own resources to the extent possible to support himself or herself. And here we have an undisputed point that the former wife is allowed to withdraw from her IRA without penalty. The IRA was worth at most $32,000 at the time of the equitable distribution. Now it has grown to more than 10 times that amount. It is worth, at the time of the hearing, it was worth $340,000. There was an analysis provided by Gamble saying that under a 72T plan, she could withdraw $1,492 each month from that without penalty, and in a way that would allow her to be sure that there would be money available for the rest of her life, that amount. Of course, I think under a 72T plan, it's actually reassessed every year. But the purpose of the formula that the IRS provides is to make sure that when you're withdrawing under that plan, there's an amount. That amount is available for the rest of your life expectancy. The case law says that the court would abuse its discretion not to take into account evidence presented that shows a spouse has a substantial source of income available but refuses to access it. And that's the Niederman case, which is one of the main cases to explain why the IRA has to be used as a source of income. And the way that we know, as I explained in the brief and was disputed in the answer brief, the way that we know that, I'm sorry, let me back up. So the Niederman case does say that you have to impute income from the IRA, or I'm sorry, it says that it's permissible to impute income from the IRA as long as you aren't going to diminish the principal. So there's one of the main disputes in this case is what does principal mean? The case law does not expressly define that, and I believe this case is a good chance for the court to clarify what that means. If you look at the facts of Niederman and all the cases on IRAs cited in the brief, it is clear that principal means the principal that was awarded in equitable distribution. And one clear way to see that is from this quote in the Niederman case, which says, here, the court in Niederman imputed income from the IRA. This court, or not this court, but I believe it was the fourth DCA, held that that was proper and explained, were the court to disregard the income producing potential of the assets awarded to the wife, the husband would be required to pay more alimony to the wife so that the wife's IRA accounts would continue to grow. In addition, I think, and more pointedly, the court said the reason that it was proper for the trial court to award or to impute income from the IRA in that case was the wife retains the assets awarded to her in the dissolution, just the same as if she were awarded stocks and bonds, not in an IRA. The Niederman case makes the point that an IRA is a tax advantage savings plan, but it's just that, a savings plan. And the Florida Supreme Court case in Mallard says we can't, an award of alimony cannot be designed to protect a savings. And as shown in the briefs, the former wife can withdraw from the account in the way that was proposed by Gamble until well after she's 72 without touching that $32,000, which was the most possible amount that the IRA was worth at the time of the dissolution. And I would also encourage you to please look at the Stoltzfus case cited in the briefs, which is a case from this court that also supports requiring an award of alimony from, or an imputation of income from the IRA. And so the last issue that I presented in the brief was that the trial court made a finding about the parties' lifestyle during the marriage that was not supported by competent substantial evidence. And that was where one of the expenditures challenged below was, the expenditure for yoga, personal training, and maid service. And the trial court made a finding that was supported by the party's lifestyle. There's no evidence to support that. So I believe that's a clear issue that needs to go back for further consideration so that the court can make a finding that is supported by competent substantial evidence. It may be that the court finds that those expenditures are appropriate, but it has to be for some reason that's included in the evidence.
You are at 15.
Thank you, Your Honor. If there are no further questions, I will save the rest of my time for rebuttal.
Thank you.
May it please the court.
You may proceed, counsel.
My name is Jean Henney, and I represent the appellee and former wife, Ms. Benini, in this appeal. The issue before this court is whether any reasonable person would have reduced Dr. Benini's alimony obligation from $6,000 to $5,400 a month. Ms. Benini would argue that the appellate record demonstrates this was a very reasonable result, especially when there was very little dispute regarding the fact. There is no dispute Dr. Benini, with an annual income of $500,000, had the ability to pay the alimony obligation. There was no dispute Ms. Benini needed between $7,000 and $7,400 a month to meet her expenses. The $7,000 figure was the Dr. Benini's expert's figure. There was no dispute Ms. Benini was 66 years old at the time of the final hearing. She was in ill health. She had a gross retirement income of less than $3,000 and a net income after taking out the alimony of $1,400. In other words, Ms. Benini was very heavily dependent on her alimony to meet her monthly expenses. At the time of the final hearing, there was also no dispute that Dr. Benini was 67 years of age. He had 2 minor children. He had 2 substantial alimony obligations of $6,000 to Ms. Benini and $7,500 to his second wife, plus child support and additional expenses for minor children's private schooling. According to Dr. Benini's financial affidavit, he had a net worth of less than $150,000. Dr. Benini's primary argument on appeal is the trial court erred in refusing to impute income to Ms. Benini's investment and retirement accounts. This is a discretionary decision. Niederman, that Dr. Benini relies on the Hallmark case, it says, after consideration of the evidence presented, the trial court may decline to impute income from retirement accounts and for equitable considerations to do justice in the case. And the court explains such a scenario might be when the amounts were small, when the payments would encroach on the principal, or when other equitable factors would permit the court to exclude the income. In the instant case, the equitable factors are Ms. Benini needs her alimony. She needs her savings. She's got expenses coming up, including dental expenses. She needs a new car. She needs a new air conditioner. These are not improper savings components. These are just saving money in order to meet her needs, which is within the trial court's discretion. I know Dr. Benini argues about her expenses for maid service, ironically, when he has expenses for maid service, and also for yoga and personal training when she testified that she needs these activities basically as physical therapy just to meet the activities of daily living.
Excuse me, and would it be a proper equitable factor be the fact that Dr. Benini's income had increased substantially?
That certainly, I mean,
I think there's no dispute that he has the ability to pay, but when we're talking about equitable factors, I mean, I'm wondering if in the background, lurking in the background here is the fact that he had a substantial increase in income weighs in at all.
Well, the trial court didn't make that actual finding, but that is one of the equitable considerations. And it's another reason that even if this court found that maybe the trial court didn't specifically say why the certain expenses were reasonable or, whatever, and send it back, you're going to come up with the same result. It's harmless error if she failed to articulate.
I feel like, and I think you validated my instinct on this with your opening remarks, that you know, the bottom, sort of the bottom line argument that you have is this is a reasonable award. Just objectively reasonable under all the circumstances. Is that it?
Well, yes, and that's what that's the standard that this court looks at. If these
Right.
an abuse of discretion issue.
The appellant's more interested in how the trial court got to that result, and you're more interested in the fact that it, however it got there, it's reasonable.
Yes, yes. And that is the appellate standard of review. Now, I know Dr. Bonini argues that the imputation of income was mandatory, but that is not true. It is discretionary, and the trial court did not abuse its discretion when you look at the entire record. And since the facts weren't disputed, this court certainly has an opportunity for meaningful appellate review to determine that a $5,400 alimony obligation in these circumstances was reasonable.
Is my understanding of the financial affidavit in 2018 indicated that she would, the former wife was paying $600 per month for health insurance, and that was the fact the trial court focused on, saying you don't have that expenditure. But I also understand in 2019, she was spending $100 some odd for healthcare, and yet the trial court gave the former husband the complete $600 reduction and not an offset for what she was still actually paying. Is that correct?
That is correct.
And so, in fact, he received a 10% reduction for his alimony payment. That's not insubstantial. It may not be as much as he wants, but it's still 10%.
Exactly. When you step back even a half a step, you realize that the reduction of $600 a month in this situation was not unreasonable. It was not inequitable. And a remand just to recalculate or to make more specific factual findings would not come up with a different result. And perhaps it would come up with a more favorable result to Ms. Bonini if it was sent back to clarify that $600 and now we have $135. But at the end of the day, what the trial court did find for this court to provide, for this court's analysis is there was an ability to pay. There was a need for alimony, and she did have some reduced healthcare expenses because of her Medicare eligibility, and her other expenses were not unreasonable, and therefore, no abuse of discretion. Downward modification was certainly reasonable and equitable, appeal affirmed. And that's what Ms. Bonini would argue. Unless there's any other questions.
I don't
Okay, thank
see
you.
any. Thank you, counsel. Okay. Let me clear the machine here. Okay. The appellant will return, and you have 5 minutes remaining, counsel. You may begin, but you are mute.
Thank you, Your Honor. Opposing counsel argued that several things were undisputed. One was that Dr. Bonini has an annual income of $500,000. But it's important to remind the court that Dr. Bonini's ability to pay was not in dispute. How much money he has wasn't relevant to the question that the trial court was required to determine, which was what is the former wife's actual need. If the former husband's current income is what was lurking in the background of the trial court's decision, then that was an abuse of discretion. Because although when you establish alimony, you have to consider both spouses' needs and abilities to pay, you still cannot, the trial court still cannot, under the statute, properly award an amount of alimony that exceeds.
That's not part of, I'm sorry, that's not part of all other financial circumstances?
Your Honor, it is perhaps something that has to be considered when the trial court is going through and addressing each of those factors. But section 61.081 says that actual need has to be determined. And this court's case law says an award of alimony that exceeds actual need is an abuse of discretion. There's also a case law saying that the purpose of alimony is not to forever equalize the parties' respective financial positions, but it is to provide for the needs of the payee's spouse. Additionally, the former wife argued that there was no dispute that that she needs that her needs equate to about $7,000 every month. That's not true. This is in dispute. What is undisputed is that she was actually spending $7,000 or thereabouts every month, but it is disputed whether that reflected her actual needs. And we don't know if it reflected her actual needs because the trial court did not do what the statute requires, which is to go through and analyze the evidence and make findings about the factors. Opposing counsel said that the former wife is heavily dependent on alimony to meet expenses. Again, we don't know if that's true because the trial court violated the statute by not making those findings and violated this court's case law. We can't know if $5,400 is objectively reasonable because we don't have those findings. So if nothing else, then I would ask that this court remand the case for express findings on the factors. And there's no way to know whether, like I say, there's no way to know whether it's objectively reasonable or whether the absence of findings is harmless because the analysis simply wasn't done.
Let me just stop you on that. Are you suggesting that we relinquish jurisdiction, remand, ask the trial court to make more findings, and then you guys, what, re-argue it?
Yes, Your Honor. I mean, I'm suggesting that is one avenue that we could go. We could take here.
And that's something you could have. Isn't that something you could have asked the trial court to do? And I don't think we've required someone that's dissatisfied with the findings in the final judgment to do a motion for rehearing and ask for those findings. I can't recall on this record if you did that already.
Excuse me, Your Honor. There was a motion for rehearing that did tell the trial court that it was required to consider the factors under section 61.08. I can't remember at this moment whether it expressly said, and you have to specifically make findings on each of those factors. But as you mentioned, this court's case law doesn't require the parties to remind the court of that obligation. And as far as
but are the findings really, I mean, I know they're for the benefit of the parties, but from our perspective, if we're able to review the case without the findings, aren't we obligated to do so?
You could determine on a proper record that the lack of findings was harmless error. I submit that this record doesn't show that because the former wife's expenditures include discretionary items.
Well, but the trial court looked at that and said they weren't. I mean, the trial court decided that it wasn't.
Your Honor, the trial court said, the only thing the trial court said about specifically the yoga, maid service, and personal training was that it was supported by the party's lifestyle. And there wasn't evidence to support that. Additionally, that finding is particularly suspect because the former wife's counsel conceded below that she may not actually need the yoga classes. And that's just one component to show how, in this case, is one clear error, that the lack of competent substantial evidence to support that finding, and to show the trial court's lack of careful attention to the evidence, which is required by the legislature in section 61.08, and for good reason, because the legislature wants to limit trial court's discretion and try to promote uniformity to whatever extent that's possible in alimony decisions. And that requires serious consideration of what actual need is. And that brings me back to the imputation of income.
You have at least 5 seconds remaining.
I just remind you that the case, thank you, Your Honor. The case in Sharon says that it is error not to impute income. And I would rely on the briefs and ask that you, at a minimum, reverse and remand for more findings and also to include imputation of income. Thank you.
Thank you. Thank you both. We hope to see you the next time, and please stay well. We'll let them transfer you out, and we will proceed to the next matter on our docket this morning. Jacobson is the matter. Case number 4. Okay, the record reflects we have everyone here. Counsel, forgive me, I was listening in earlier this morning, but your jacket is not moving or doing anything here. In this proceeding. I was
I'm glad to
testing
know
my
that.
equipment.
Thank you. One less thing to be worried about.
Yes, dear, you're coming in clear and fine, and you're not moving, although I noticed earlier today my robe was twitching in one of the oral arguments, so hopefully I'm closer behind the green screen now.
I assure you I won't notice. I think it makes you more nervous when you have to watch all of the other arguments in front of you, but
I thank you for that. I will need to ask you, since I am designated as Center Chair today, I'm also the timekeeper, so I get time to multitask. Would you like to reserve any time for your rebuttal?
I would, yes, Your Honor. I'd like to reserve 5 minutes. Thank you.
And I will do my best to let you know when you arrive at 15 minutes. I know you know that if you wanted to keep going, it's still your remaining 5 minutes. We just subtract them from your 20. That's all. So it's not one of those where you have to sit down right then or stand. It's your time still. With that being said, counsel, we are ready to begin. And as they say, the floor is yours.
Thank you. May it please the court. My name is Shannon Zettrauer, and I represent the appellant Sharon Jacobson. This appeal raises 3 issues based on the legal interpretation of a postnuptial contract between former spouses regarding the equitable distribution that would occur upon the sale of the marital home. In each instance, the circuit court's judgment conflicts with the plain language of the postnuptial agreement. First, the final judgment conflicts with the plain language of the postnuptial agreement that requires all benefits realized from the sale of the property must be included when calculating wife's share when the sale is not a bona fide sale. The side letter agreement is the primary reason why the sale was not a bona fide sale, although it also wasn't a bona fide sale because it wasn't an arm's length transaction, as the buyer admittedly had a financial relationship with an interested party, Mark Jacobson. Appellee conceded below that this was not a bona fide sale. That's not in dispute, precisely because the sales transaction included $500,000 for unvalued.
Did they concede it wasn't a bona fide sale because the son found the buyer and he's a beneficiary under the residence, should he live long enough, the owner, and that element of the contract caused it not to be a bona fide sale? Was that correct?
Yes, Your Honor, and they also conceded that it was not a bona fide sale because there was $500,000 of personal property that was sold not for the fair market value.
Okay. Did they say the value was higher or lesser?
They didn't know.
Okay, so going back to your first point, is to prohibit benefits from the sale of the property. And the property identified in the contract to which the former wife had an interest was the house and the adjoining lot. This is a sale of personalty. What's the nexus, if any, between the two?
The nexus, Your Honor, is the fact that it wasn't a bona fide sale. So because it wasn't a bona fide sale, and if you look at the agreement, it gives several specific examples of what would not make it a bona fide sale. And the first example is if there's a corresponding or related sale of personal property that is sold that's not for the fair market value. That's what happened here. So that makes it not a bona fide sale. And what the agreement does then is it changes the formula for gross proceeds to include the amount for that personal property. So that's how the personal property became a part of the gross proceeds. The personal property would not have been a part of the gross proceeds had they either not sold it with the house or they could have sold it with the home, and all they had to do is sell it for the fair market value.
Who would have the burden of establishing that it wasn't fair market value? I mean, there's a list of all the attachments. The property belonged to the former husband. Why does it matter if he sold it for less than it was worth?
Because that's what the agreement required. We don't know if he sold it for, I mean,
that is part of my concern. The argument to benefit the wife says it has to benefit from the sale, and the benefit suggests that it has to be a positive, and there's no proof in this record that it's a positive that he benefited. He just sold his property, and everybody agrees it's not for fair market value. That means it's either up or down. One's a benefit, one's a loss, and that's how do I address that in terms of as you argue, the strict language of the agreement, Or am I going too far afield?
Well, no, Your Honor, I think it's a good question. The benefit is $500,000. That's the benefit. That's undisputed. No one is disputing the amount
So
of
whatever the
benefit.
sale price is, it would have been a benefit. So if he'd have sold it for $100, then your argument it would have been, we'd have taken an appeal for the $100 because it should have been in the gross proceeds? Or is there a point where that nexus, he has to benefit from it? I mean, a
No.
positive, so any amount of income arguably would then be a positive gain? Is that it? Any amount of sale price would be a positive, i.e. therefore a benefit?
Exactly, Your Honor. Then it should be included in the gross proceeds per the formula in the agreement. I don't know that we would have appealed it for $100.
I know, I didn't, that was just a, my concern there is if the purpose of this clause was to make sure that the husband didn't park proceeds over in the sale that would have otherwise been in the other portion of the sale proceeds under the contract, I'm not sure the record clearly displays that's what happened here. I mean, that clause is to protect the former wife from saying the husband sells a market value property of 100 units at 50 and then parks 50 over there somewhere else and saying, oh, you only get 50. In this case, it appears that it was sold above the appraisal price. So that causes some concern about the nexus and the benefits. And I'm trying to figure out how all this should be interrelated, if at all.
And Your Honor, you hit on a couple of key points that I wasn't going to get into, but the first draft of the side, or the first signed copy of the side letter agreement saying they would give $500,000 for personal property listed no personal property. So it does appear what you suggested happened, where it was, we're going to park $500,000 of the sale price over here and deem it for personal property. You also mentioned the appraisal, and I believe when you say the appraisal, you're talking about the appraisal of the marital home. And the
did not
agreement,
include the adjoining lot because that would have had a value too, right?
it did. It did include the adjoining lot. However, it didn't appropriately account for that. However, I would say the appraisal is a bit of a red herring, and I can spend time on it if you'd like.
No. I mean, part of the agreement says the adjoining lot's not the property of the wife anyway. At least one of them did. I know if it was the first one, the second one, I'd have to go back and double check because I don't want to, there's a lot in your record.
Right. She was entitled to the adjoining lot as well, Your Honor. However, the appraisal is irrelevant because the agreements, first, they didn't trigger the appraisal process, which had to have been done within 15 days of the sale. They didn't bring it up till 18 months later. But also the appraisal, the agreement states that it's either the higher of the gross proceeds being the sales price plus benefits realized or the appraisal amount. So unless we had an appraisal that was higher than this amount, the appraisal is irrelevant anyhow. But while we're talking about the appraisal, I will also mention that it did state in it that it was based on extraordinary assumptions. It was done from the curb without going inside of this home.
He had
And
walked back in the house for
errors
quite a
with it.
while. Yeah, he said he saw it one time before, but didn't go back in.
Right, 6 years before. And I really don't, I'd be happy to address it because there are a ton of
No, I
issues
don't want
with
to take
that
up all your
appraisal.
time.
But
I
I do
just
think,
you've addressed my question about the interlocking aspects of the language.
okay.
I
And I
just
know
make
you
sure
gave
that I
someone else
understood the
2 extra
arguments.
minutes, so I may need that, but let's keep going. All right, thank you, judges. So the side letter agreement, as I said, was the primary reason why the sale is not a bona fide sale. And we just discussed that quite a bit. Appellee conceded this was not a bona fide sale because of that $500,000. And because this was not a bona fide sale, that formula changed. So the formula to determine gross proceeds was no longer just the sales price. It's now the benefits realized by the husband pursuant to the transfer plus the sales price. And there's no dispute that receiving $500,000 for some amount of personal property is a benefit realized by the husband. The postnuptial agreement pursuant to the transfer, it's a benefit realized pursuant to the transfer. And the postnuptial agreement's definition of transfer is very broad. It's any sale of any interest in the property in any manner whatsoever. Postnuptial agreement required the property to be sold in a transaction meeting all of the requirements of a bona fide sale and prohibited husband from engaging in any transaction or transfer or agreement concerning a transfer that evades or avoids the bona fide sale requirement. There's no question that that $500,000 was a benefit realized by the husband pursuant to the transfer of the marital home, and an agreement concerning the transfer of the marital home. The marital home sale and side letter agreement's personal property sale closed simultaneously. The contracts reference one another, and the side letter agreement was contingent on the marital home's closing. Had it not been for that sale.
I saw that in your brief, and the question I have is, I mean, in any sale of property that's located inside of a residence, if the residence doesn't actually close, you're not going to go forward with the sale of the personal property. So, I mean, going back to what you said earlier about them not having a list of the property, this was basically the contents of this house, was it not?
I don't know, Your Honor. We were not permitted to go in and see exactly what was sold, so we don't know. But there was a
substantial
lengthy
list. This wasn't just, hey, I'm selling you the dishes and the dining room set for $500,000. This was a substantial amount of property, correct? Basically selling it as furnished.
There was quite a lengthy list.
You should proceed.
Thank you. Second, the circuit court erred by crediting husband for claimed capital expenditures that lacked the adequate backup documentation that the postnuptial agreement expressly required before such expenses would decrease wife's share of the sale proceeds. Under the agreement's plain language, those claims had to be excluded. The postnuptial agreement required strict performance of its terms and conditions, and even stated that substantial performance in good faith would not be sufficient. The postnuptial agreement's process was straightforward. Husband was to notify his wife of the claimed expenses, then she had the right to verify his records to confirm that these were actual capital improvements pursuant to the strict terms of the agreement. Rather than hold the husband to the postnuptial agreement's unambiguous and strict record-keeping requirements, the circuit court permitted appellee to support all of his pre-2011 claims, which were 102 in total, totaling over $200,000, without a single document and evidence to support those. 0 documents cannot constitute adequate records or backup information documenting those claims. Allowing those claims with no evidence was error as a matter of law. For the 2015 to 2016 purported capital improvements, there were some records, but they were substantially lacking. There were no records to show that husband actually paid for these claimed improvements. The bulk of those improvements were paid via check from a Morgan Stanley account, but there wasn't a single record or piece of documentary evidence showing the owner of that account. Instead of the records, appellee presented the testimony of Mark Jacobson, husband's son, and that testimony was inadequate for 2 reasons. First, the testimony was inadequate per the postnuptial agreement's plain language because records were required. No testimony could be adequate because testimony is not records. Second, even if the testimony could be records under the agreement, which it cannot, Mark's testimony was inadmissible to establish that husband owned the subject Morgan Stanley account because his purported knowledge that husband owned the account in question could only come from reviewing the unadmitted business records. Our briefs lay out the case law on this, but when a witness testifies as to the contents of business records, the business records must be in evidence. Otherwise, the testimony is inadmissible, and allowing Mark to testify without the account records and evidence was an abuse of discretion. The postnuptial agreement's records and documentation requirements mean actual records, documents, not testimony of people who benefit if wife receives less. When the circuit court permitted appellee to substitute trial testimony, it rewrote the terms of the agreement and deprived the wife of a key protection she bargained for and received under the agreement's terms. Without the records, wife had no ability to determine if these were true capital improvements, and the requirements for those to be included as capital improvements under the agreement were very strict, and she was unable to perform that analysis without all of the documentation. It's undisputed that 0 underlying records were admitted to establish the pre-2011 expenses, and those claims must be stricken. Further, no record shows that husband paid for the great majority of the claimed improvements from 2015 to 2016. Third, the circuit court erred by crediting the husband for his attorney's fees when the postnuptial agreement only permitted a credit for reasonable selling expenses paid to an independent third parties. The husband's claim for $15,000 in legal fees as a reasonable selling expense was raised for the first time in this litigation at closing argument. It was not claimed in the complaint or after the actual closing of the property. Wife timely objected to the inclusion of these amounts. There is no evidence, let alone competent substantial evidence, that husband's attorney's fees were independent or reasonable, and therefore they cannot reduce the net proceeds. Appellee and husband had all of the records that would document these expenses. They chose not to provide them to wife, which prevented wife from proving that they were not legitimate expenses per the agreement. To briefly conclude now, the circuit court was required to interpret and enforce the postnuptial agreement's plain language and expressed intent. Instead, its ruling read out key language and excused noncompliance with several material provisions. These legal errors should be reversed and remanded with instructions to amend the judgment to include for wife $250,000 for half of the benefits realized from the side letter agreement, $102,692.92, which is half of the entirely undocumented pre-2011 expenses, $291,558.17, which is half of the insufficiently documented 2015 to 2016 expenses, and $7,592.50, which is half of husband's claimed selling expenses for attorney's fees. Appellee referenced in his brief that a wife wants another pound of flesh, but that's not true. Husband lived in the marital home.
I thought you were about to sum up with the numbers, so I didn't interrupt you, but you are past the 15. I just want to make sure you knew that.
Okay, I'll wrap up right now then, Your Honor. Husband sold the home for $6 million and afterwards cut wife a check for $11,000. Wife doesn't want a pound of flesh. She merely wants her equitable share pursuant to the unambiguous terms of the agreement. Thank you.
Thank you. Mr. Samarcos, you are muted. I think you want to speak with us, and you are still muted according to you're good now. Okay.
You know, I've been watching that and I said, I'm not going to do this. And then I just,
I keep catching myself here, and trying to make sure in case I make a noise over here, I'm muted and so I don't disturb you. And then I know I'm trying to advise counsel, I'm sorry you're there. And I'm going, oh, I'm muted. I got to turn myself back on.
We all do it.
It's funny. I was telling somebody, I haven't been in a courtroom since March of 2020, and I've been practicing 32 years. And it really is a completely different year. I'm like old now, and it's very difficult to adjust to not being in front of people. And the mute thing happens to me frequently because I try not to interrupt. So thank you for telling me.
Well, as I say, the counsel, the floor is yours now at this time. You may proceed.
May it please the court. Thank you. Charles Samarcos, I'm representing the appellee, Martin Jacobson, who's the trustee of his father's personal residential trust. I'd like to start with the first argument that was addressed, which is the sale of the personal property. Factually, by background, what's critical in this case is that if you look at the agreement, and especially in subparagraph 2, the nature of the wife's interest is critical because the parties agree that it was the intent and the agreement of the parties that the additional amount that the wife would receive would be equitable distribution for purposes of marital assets and liabilities. Why this is critical is because all of the personal property we're talking about is husband's separate property, either acquired post-marriage or abandoned by the former wife under the 1994 decree. So therefore, when the court, especially the lower court, and these were argued, is looking at what the intent of the parties was, this is equitable distribution. And I know that your honors are aware, courts don't have jurisdiction over post-marital assets to then say, we're going to go back and look what somebody acquired later and equitably distribute them after the marriage. That's why this is a critical agreement. When looking at the overall intent, they want to say, well, we're taking out the word benefit and we're ascribing to it a meaning that he got a benefit, therefore we get that money. But
you can agree to something in a marital settlement agreement that trial courts can't authorize. Isn't that correct?
You can personally agree to it, but the difference is that they said that this was only going to be equitable distribution property, which would be assets and liabilities that were owned at the time of the marriage, not subsequent. And the problem with that, Your Honor, is that these assets are subsequent because, number one, after a year, they weren't removed. Number two, they were personal property and it's not established that all of it existed at the time. The furniture, the fixtures, the piano, there's no establishment of that. So that's a critical factor. Also, Your Honor, when looking at the transfer and the benefit, and this was argued at the lower court, and it was also even established by Mr. Braunstein's testimony. Had this house sold for $4 million, and let's say Mr. Braunstein, I think, said a Ferrari, and the sales price on the contract said $4 million, but there's another document that's a bill of sale that transfers a Ferrari. Clearly, that would have been a benefit received for the sale because Mr. Jacobson's trust was going to be receiving something of value. That was a benefit to him. Or take it away. Let's say that he sold the house and there was a promissory note that was reduced by $1 million. Let's say that that Mr. Jacobson owed the buyer $1 million and the buyer said, okay, I'm paying you $4 million for the house and the $1 million note I'm canceling. Clearly, that's a benefit to Mr. Jacobson that would be included in the sales proceeds. And the other thing that happens with this, like in typical transactions, sometimes somebody stays rent-free 6-7 months later. That's a benefit received. I'm selling the house. I'm staying there for 6 months. There's no testimony like that any of that happened. What they argue is, and Judge Casanova, I think you nailed this on the head with the hammer, because there is no testimony that the personal property sold was a benefit. All that happened is that one asset in the form of tangible personal property was converted to another asset in the form of cash. But there is no testimony that there was a gain, that somehow the grand piano, the piano was sold for $100,000 more than it was worth, or the glassware or the furniture. In fact, to the contrary, there is no evidence to say that this was not an arm's length transaction on the personal property. And even to the contrary of that, the former wife's testimony as a decorator essentially established that if you were to look at square footage and what decorating costs are for a house of this size and magnitude, it would have put the price of those improvement of the personal property over $900,000 to necessarily replace that. But those are critical factors when looking at there is no benefit. They're claiming that by converting an asset into cash from another type of asset, that's a benefit. And that's simply not the case. There's nothing to say that there was any gain or that anything was realized from it. And that's a basis to support to say, look, there is no benefit that was received as that term benefit is contemplated. And especially when looking at the whole agreement, and it talks about it's the sale, the transfer is of the marital home and the adjacent lot. There is nothing. What she's talking about is a different paragraph to say, hey, you can sell personal property and get a benefit, but that's again, selling it for undervalue. And that's what we're looking at when we're talking about the situation with the personal property. So, and Judge Stargell, I think, hit on this, but we're talking furniture, tools, equipment, dishes, glassware, silverware, art, electronics, gym equipment, and furniture in multiple bedrooms, including basement, kitchen, family room, foyer, dining room, living room. This is a huge house. So for the former wife to say, I get that now, or I get half of that when she had absolutely no interest in it, and it's only for equitable distribution of a marital asset, is opposite of what the agreement says. And it supports the trial court's findings to say that side letter agreement for the sale of personal property is not subject to the wife's claim in this case. I'd like to move on to the second argument now, unless anybody has any questions on that portion of my argument on the side letter benefit claim. The second argument, Your Honor, is on the capital improvements. And Judge Casanova, I think you started with this on the first argument. This was a 2.5-day trial. And in that first argument, you pointed out that the appellate court doesn't sit to reweigh the testimony, the credibility of the witnesses, and then try and see, hey, would I have decided this case differently if I had heard this? Judge Jaraka sat for 2.5 days listening to testimony about these issues. He listened to the testimony about what were the improvements. What are we talking about here? A putting green. Mr. Braunstein, I believe, testified he was out at the house. He saw a putting green. It's on a spreadsheet. That's a capital improvement. So the first factor that I would point out to the court is that the former wife's case is really having this court try and reweigh the evidence and the credibility of the witnesses. It is not to look at it and determine it for anything else other than that, to say, we had our chance and we lost, and now we're going to come back in here. And the testimony of Mr. Jacobson, the son, they point to and say, well, we've got this issue now. We believe it's hearsay. Your Honors, we have cited it, but the hearsay cases that they cite, and it's important. The first case, they have the AS versus State case, and that was at 91 Southern 3rd 270. It's a 2012 4th DCA case. Interesting about that, Your Honors, is that it was a theft case or damage to a property. The garage owner was trying to testify off of the estimate that an employee had prepared. And the court said, look, the estimate didn't come in as a business record. But what is critical is they said, we're going to exclude that because he didn't testify that he had personal knowledge. They specifically said in the footnote, we note that the owner's testimony would not qualify as an expert opinion because he only testified as what was contained in the estimate, rather than evaluating what should have been included with the estimate and view the photographs. Had the owner looked at the photographs and said, I have knowledge of this, I know what to do, this is the damage, this is the estimate, the court would have had it. But they weren't doing that in that case. The other cases that they cite, the Thompson versus State case, interesting about that, there's a bill of lading that comes from Woolworths. When the bill of lading, it has how many product is out there. The people that were receiving the shipment testified they didn't get all the product on the bill of lading. The state didn't call any witness from Woolworth to say that's a business record, that the individual that wrote down the quantities was a person with knowledge at the time. We maintain a bill of lading as part of our regularly business practices. We put this down as part of the business that we conduct. And our records custodian would say, hey, yes, that's a copy of our bill of lading. So the appellate court looked at that and said, look, that is at odds with what the rule is for evidence. The other cases that they cited, again, when we're talking about personal knowledge on a note, the people that testified from the bank didn't know what was owed on the notes, and the court said you can't do that. Now, what we cited in the case, though, we cited one of this court's decisions in Mid-Florida freezer warehouses, and that was a 2010 decision, and this court found at 41 Southern 3rd 1014. There was an unemployment decision in that case, Your Honors. The former employer testified, I saw this gentleman come in late. I personally counseled him that he was coming in late. I wrote him up. But the referee in that case said, look, all you've got are all these documents of him being tardy. And I'm excluding those as inadmissible hearsay because there's no business records that are introduced and there's no proper predicate. And in that case, this court noted that much of what the former employee testified was within his personal knowledge and was not hearsay. Therefore, there was a reversal to say that all that was inadmissible. Hearsay, Your Honors, is not when somebody's testifying from personal knowledge. We spelled it out in our brief, but the court specifically asked Mr. Jacobson, how do you know this? Mr. Jacobson said, I have personal knowledge. These are my father's accounts. I'm at Morgan Stanley. I know what improvements are in there. That is completely different from hearsay, where the witnesses that the cases they cited had no personal knowledge. That takes it out of the realm of hearsay. If the court were to adopt their standard, I couldn't walk in and say, that's my bank account, or I paid for that car, because I don't have the business record from Bank of America saying, this is a custodian, this is Mr. Samarkas's account, and this is what it says. That's not the purpose of the hearsay rule. The hearsay rule is to stop somebody that doesn't have personal knowledge from being able to testify unless there's an indicia of reliability. And that's why in a business record, that's met with the records custodian being able to set the testimony. So once Mr. Jacobson gave the personal knowledge, and by the way, Judge, this, Your Honors, he was out there frequently. This isn't somebody that went by casually. And we're talking about he's maintaining the accounts, overseeing everything that's happening with the accounts. He certainly has the personal knowledge. As to the schedules and the documentation, again, this is going to the weight of the evidence. We're talking about capital improvements. I go back to the putting green, partly because I'm a golfer and I think that's probably great, but anybody can see a putting green in the front of a yard. There's no dispute it's a capital improvement. The wife didn't walk in through her testimony and say, there's no putting green out there. How are they getting something for a putting green? There's no fountain out there. There's no improvements in the basement and the ground floor. There was opportunities even during there's nothing in the record that says they had no opportunity during the litigation to go out and dispute it. The only expert they put on is to say, we don't like their documents. Their documents are insufficient. But the expert that was the Appleese expert said, look, I look at the totality of circumstances. I look at what the testimony is from what Mr. Jacobson said. I'm looking at spreadsheets that have that, and I'm looking at the fact that these capital expenditures exist out there, that the improvements are actually there. That's the weight that the court gave that testimony. And then be able to say, no, we're going to go to some part of the agreement and say, gotcha. You don't have a receipt from 23 years ago saying that this was what you paid for the green. Therefore, I get the benefit of that. That's just not in keeping with an accordance of what the agreement says and what it was the parties to do. And when we look at the adequate backup documentation, there is the issue about the trust, that somehow his trust isn't him and he can't pay that amount of money. It's nonsensical. We mentioned this in the brief, that who is putting in $800,000 worth of improvement on a house and not paying for it? Who is writing checks to the guy putting in the basement, to the individual? If the company that's putting up I keep going back to the putting green, but the putting green, who's putting all those improvements in and paying for it if it's not Mr. Jacobson? There's no testimony that he had some grand benefactor out here that was paying for all of this. In fact, to the contrary, his son testified, no, he paid for everything. So the argument that they're saying that somehow, because there's no proof of anybody paying for this, is contrary to the evidence. And it certainly is contrary to the evidence that the court considered when the court was looking at the testimony and how to evaluate it. The other thing that the expert testified to that's important is that the expert, when I say the expert, Ms. Mills, our expert, she looked at what is the requirements for a capital expenditure. These are not maintenance issues. It is important to note, though, that Judge Duraka did ding my client for not maintaining it. He knocked off the price. He said, you're supposed to maintain it. You didn't maintain it. I'm taking 50 grand out of your column for that because you didn't do what you needed to do. There was testimony about whether these were capital improvements, whether he was maintaining the house, and what it is. And the expert who's looking at the IRS code and who is somebody that's a CPA and who's testified for many times, she testified that these expenditures were capital expenditures. And by the way, the judge also didn't accept 100% of what she said, because the judge did knock down some of the capital expenditures and the capital improvements that were done. But clearly, Your Honors, the court looked at the fact that this agreement was not to benefit the wife by having the husband make capital expenditures over 23 years. And because he didn't have a receipt 23 years ago, even though there was testimony that it was done and it was paid for, that was somehow insufficient to demonstrate there was a capital expenditure, and now the wife gets the benefit from it. Especially, Your Honors, when you look at equitable distribution and say there is only the intent to give the value at the time that the asset existed, not to give the appreciation on an improvement that was not an asset in existence at the time of the marriage. Your Honors, the last thing on the attorney's fees, and we put this forth in our brief that we believe it's been waived, but this is an attorney fee to close a $5.5 million transaction for something that was $15,000. Clearly, that's benefiting the sale to go through a complicated transaction with the sale, waterfront property, lots, making sure the agreements have the appropriate contingencies in them, the appropriate conditions in the appropriate representations, and to now all of a sudden say, well, the husband has to basically eat all that and the former wife doesn't have to pay any of that when it's on the closing statement. And they have an opportunity to come in and say, well, we don't think that's legitimate because you weren't doing work on the closing on that. They say, well, we don't know what it was, but there's no evidence that they tried to know what it was, or they brought in an expert to say that's an unreasonable amount of money. And by the way, Your Honors, they didn't bring in any expert to say that these capital expenditures that were made were unreasonable and the values weren't there. They didn't bring in any expert or an appraiser to say the personal property was worth more than what it was sold for, and somehow this is a benefit. What they did was to sit back and say, we don't think you've given us enough information, and just at every turn, just say, we don't think it's enough. We now get the benefit from it, or the former wife would say that. In conclusion, Your Honors, unless there's no further questions, I thank the court for the time. We ask that the court affirm the decision of the lower court. Now you're on mute, Judge.
I noticed that just before I spoke, so your mind was working just like mine. Okay, thank you. Counsel, I intended to make sure you preserved your 5 minutes. I have, despite going over the last time. You mentioned that you might need the extra time. You have received it, so you have 5 minutes for your rebuttal. You may proceed.
Thank you, Your Honors. Appellee wants you to focus on items other than the applicable terms of the agreement. They cited numerous red herrings. First, as far as the side letter agreement, what happened is there was $500,000 given for property that was sold not in accordance with the fair market value. We requested to inspect that property to evaluate the worth of it. Appellee objected to our inspection of the property. They now rely on my client, wife's testimony as to the value of that property, which is irrelevant. She testified as to what it would cost a decorator to put brand new furniture in a brand new home per square foot. That doesn't determine what the actual value of this property was. The problem here is the property could have been worth $50,000 or it could have been worth $400,000. We don't know. We have to speculate. And without having that information, we're unable to determine how much wife is owed. If it wasn't the $500,000 and we don't know what it was actually worth, then that is unfair to wife and is not a fair reading of the agreement, which specifies that in this exact circumstance, where property is sold, personal property is sold in conjunction with the sale of the marital home and not for the fair market value, and the agreement doesn't say for less than the fair market value, the agreement just says not for fair market value, then that amount has to be included. We're bound by those terms, which both parties agreed to when they signed this agreement. We're not asking you to weigh testimony here. We're asking you to apply the unambiguous terms of the agreements. Regarding Mark's testimony in the business records, testimony regarding business records without the underlying business records is inadmissible hearsay. One piece of paper which wife requested and appellee refused to provide would have shown who owned that account in question. We don't know because they refused to submit those records and chose instead to rely on testimony of someone who is admittedly a witness who would gain for wife's loss in this case. I wanted to address the importance of the documents. Opposing counsel mentioned the putty green, and if you see it, then it's there and it was an improvement. But the problem is, Your Honors, how much did it cost? Without the documents, we don't have pertinent information that needs to be addressed in order to determine wife's equitable share. Without the documents, wife's expert was unable to determine if these were capital improvements. Appellee and husband had the advantage because they had all of these records and did not provide them as they were required to under the agreement to wife. This prevented wife from being able to conduct the analysis that was necessary. Opposing counsel mentioned assets that were not in existence at the time of the marriage. And I think it's interesting that he pointed that out because the huge $800,000 worth of improvements that were reportedly done in 2015 and 2016 were supposedly to install windows at the property, storm windows. But the testimony showed that storm windows were actually in place at the time the property was built in 1995. And that if you look at all of the records, it shows numerous window replacements over the years. And as he said, you can't get credit for what as a capital improvement for what was already there. It has to be an actual improvement. And without all of those documents, wife was prevented and her expert was prevented from making an analysis as to whether these were capital improvements. A great example of why the records were necessary are the Coley invoices, which are pages 5261 and 5262 of the record. Those were the only two invoices submitted that actually showed what work was being performed at the property, why it was being performed at the property, and the cost of that. And those were the only two that the judge struck. He struck them because when you actually saw what was being performed and why it was being performed, it was obvious that these were not capital improvements pursuant to the agreement. And this exemplifies why the records were so important. To summarize, again, the side letter agreement, it's simple. The agreement stated that if you sold personal property as part of the real property transaction for anything other than fair market value, you have to include the price of that personal property into the gross proceeds. For the capital improvements, 0 records cannot be considered adequate records. And for the attorney's fees, there was not evidence that it was a reasonable and independent selling expense. Yes, it was on the closing statement, but after the closing, appellee did not ask wife to contribute because they knew at the time of closing that those were not independent and reasonable expenses for the wife. So they chose not to bill it to the wife at that time. They only threw it in as an argument in closing arguments. So unless you have any other questions, I will rest now on our briefs, and I thank you. You're on mute, Your Honor.
You are absolutely correct. I was on mute. So we will say thank you very much to both counsel. I appreciate your presentations this morning. I think I speak on behalf of the entire panel. And that will conclude, I think, what they call our morning session. It's approximately 12:05. We'll take a 10-minute recess and come back for the afternoon session. So I guess I will say we are in recess at this time. Thank you very much.
Thank you, everyone. Well, there you go. What was their case?
Still on finishing.
I'm unmuted now. We are ready to resume our 11 o'clock session at this point. If you would please send in the parties on Lifesey and Victoria Lofts. We are ready to go.
Judge, we're trying to get the other party in. They had issues when we did the test at 9:15. So they have to hold off a few minutes here.
Do you want us to proceed to the last case and do that one at this time? While you're working on him?
Yeah, IT is trying to get him in. We had this issue at 9:15 and they never were able to get him to come over to our side here.
Okay, we'll wait a couple of more moments for them to see if they can obtain success.
Yes, sir.
Thank you.
Judge Casanueva, Mr.
Debbie
Davis
Meek.
just needs to turn on his camera, but with Mr. Lipsey, I'm not sure if he's listening, but if he has a message on his screen that's asking him to promote to panelist, he needs to accept. If he doesn't see that, then we're going to have to allow him to talk and not be on the actual screen because I can not move him over.
Okay, well, can you put him on audio and tell him that? And if not, we'll just proceed. Mr. Davis now shows up on my screen.
Yeah,
I see him quite clearly.
I think
And
Mr. Lipsey's coming over, or Miss Lipsey. They just need to turn on their camera and their microphone.
Good afternoon, Your Honors. I think my mic is now on.
It is indeed, sir. And Mr. Lefsey seems to be coming in.
Thank you.
Good, he's here.
Sorry for that. I was connected with a different computer and it wouldn't stay on. And so I had to go to a iPad. I apologize, Your Honor.
It's not a problem. We try not to start without you.
Thank you.
Okay, we have this matter. Mr. Lifsey, you represent the appellant in this case, and did you wish to reserve any time for rebuttal?
3 minutes, Your Honor. I don't believe we're going to use up all of it anyway because it's a very short situation.
Okay, sir. I have made that notation, and should you get to 17 minutes, I will let you know.
Thank you very much, Your Honor. I certainly appreciate it.
You may proceed.
Thank you. May it please the court. My name is Stanford Lipsey. I represent Lipsey Real Estate and Holdings. This is based here today based upon a writ of certiorari where my client had sought to take depositions of parties and of witnesses as in preparation for an attorney's fee hearing and cost before Judge Huey. Judge Huey entered an order based upon the plaintiff's motion to quash and any alternative for a protective order against the depositions of Jonathan Ellis, Jason Davis, Caitlin Staley, Bona Larson, Rick Penza, and Jenny Gonzalez. The first three individuals of Ellis, Davis, and Staley were all attorneys who participated on behalf of the plaintiff in this cause. And Mr. Davis and Ellis and Staley all entered entries into the attorney's fees, and we had asked to be able to take their depositions. Bona Larson was also an employee of Shoemaker, Lukeman, Kendrick, and she was considered what they call a specialist. And she's the one who did all the accountings, and her entries were rather specific also. Mr. Rick Penza and Jenny Gonzalez were both presidents of Victory Lofts, and for which we wanted to take their depositions in order to properly prepare for the hearing. I will advise the court that the hearing did go forward yesterday because this court denied the stay on a writ, not on a writ, but on a motion where the lower court denied the stay and or continuance, and we requested the stay in the appellate court, and the appellate court denied that stay. So we did go to the hearing yesterday. Unfortunately, some things came out, a lot of things didn't come out. We were not totally prepared.
Well, what happened yesterday will not be in our record, so we probably ought not to refer to it, counsel. I don't know if it renders anything moot, but we are limited to what the trial court originally had before it when the order that you took on appeal was issued. And that's the one that we're here on today. My question to you on that order is, normally a writ of cert is available when the court says it denies a deposition of a material witness. And I'm looking at that part of HEPCA, which I think both parties have noticed in their brief. And in HEPCA, there was a proffer of the testimony that the witnesses were intended to put forward, or at least there was a proffer of the belief. You mentioned earlier what you thought those witnesses were in terms of capacity. Was that in the record at the time of a proffer or something similar along those lines that the trial court would have had before it entered the ex parte order?
Absolutely, Your Honor. This case has been going on since 2014. Judge Huey took over in 2016. So he is intimately familiar with all of these people. He in fact instructed counsel to have Ms. Gonzalez file an affidavit. Mr. Penza, who was the president of the association, filed affidavits. I believe he's still the president as we sit here today. The court had participation completely from Mr. Ellis and Mr. Davis. Ms. Staley, to answer your question, he was probably not familiar with her because she was in the very early part of the case before it was transferred from county court to circuit court.
The issue here is on attorney fees. And so I probably should have limited to you that, since we are here on discovery deposition for attorney fees, and that would, to make them a material witness, it would have to be asked to that issue, and they would have to have knowledge, and the court would have to know for the definition of material witness, there's usually an accompanying proffer that shows why they're believed to be material. And now I just want to make sure that was in our record.
Yes, sir. I mean,
okay,
Mr. Ellis and Mr. Davis are two attorneys who continuously appeared before Judge Huey. Mr. Penza and Ms. Gonzalez each filed affidavits, and for which the court accepted those affidavits as part of its ruling in the initial case itself. And without that, I was not able to, I can't talk about what happened yesterday, but we were not able to properly prepare for purposes of the defense in this case because we were excluded from their depositions. If you look at the court order that the court entered, unfortunately, it doesn't comply with the HEPCO case. And Your Honor, you were one of the
Indeed, I was. Judge Smith wrote a very good opinion.
I'm sorry?
I said Judge Smith wrote the opinion, and I wouldn't. He was on the panel. And I think the Harley case, the Harley Cats case I authored way back when. Yes, sir. Yes. That is accurate.
And I'm looking at the opinion itself, and the opinion cited, it says here, the order under review departs from the essential requirements of the law because the trial court made no findings, and there's nothing in the record before us to rebut the suggestion that there is a material witness and there's no finding of good cause to preclude this particular deposition. The order that was entered by Judge Huey merely states that the depositions are quashed, that the parties shall coordinate on a mutually agreeable date by May 14 of 21, the deposition of, quote, only one attorney at Shoemaker. Well, there was multiple attorneys in this case of Shoemaker, and there was probably 6 attorneys that all had entries into these attorney fees cases, into these attorney fees affidavits. And those are some of the people that I wanted to take. But I was starting with Ellis and Davis and Staley. Staley was the one who actually filed the case and then took over It was taken over by Mr. Davis and then by Mr. Ellis. So, I mean, I got to that point and then I tried other ways to take depositions and that didn't happen either. And it says the only topic from Shoemaker will have to testify about is the fees and costs. Well, initially the court order, when he made a finding of entitlement, said you can take the attorneys 3 hours per attorney. He didn't limit me to one. It's on this motion that came before him on the protective order that he now limited me to one attorney from Shoemaker. And Your Honor, that precludes talking to the people who actually did the work, determining whether or not it was necessary and going way into it, which I was precluded from. It's not a matter that can now be corrected on appeal under any circumstances. And it is very prejudicial to my client. I've never been able to even speak to either one of Penza or Gonzalez as to the validity of the contract and the way that the contract is written. And what is the obligation of victory loss based upon this contract? I mean, these are all matters that could be subject to the defenses and are the defenses that we had, but I couldn't get to them. So therefore, Your Honor, we believe that we have established the prongs of the test that is necessary.
Excuse me, I want to make sure I understand. This was a hearing to determine the reasonableness of the amount of fees that they sought?
That is correct, ma'am.
Not entitlement.
$260,000 worth.
Right, but not entitlement, just the reasonableness of the amount.
Yes.
Okay, and you were provided with their affidavits prior to the hearing on the fees?
Yes.
Okay.
I was provided with the affidavit signed by Mr. Davis, and I was provided with the entries of the various of the 5 or 6 attorneys as to what services they provided.
Okay, and
I was not provided anything from either Penza or Gonzalez, who were the presidents of the association during these proceedings.
They weren't attorneys seeking fees, were they?
No, they're not attorneys, but they're the representatives of Victory Law.
Okay.
With that, thank you very much. With that, we believe, first of all, and I didn't bring it out, but I mean, when the depositions were set, they waited 21 days to file an objection after having received the notice of these depositions. And that was like 5 or 6 days or 8 days before the actual depositions were set. And the judge conducted this hearing. He didn't conduct a hearing. That's unfortunate, because I was not given any input to it. He reviewed the motion as filed by Mr. Davis on behalf of Victory Loss and all these people, and he granted it. So I didn't even get a chance to argue my side as to why I needed these people or why I felt that they were necessary. He knew who they are. He knows who they are and knew who they were and was intimately available. But we feel that we have justified and satisfied the requirements that this court, based upon this writ of certiorari, return this back to the court and order that these depositions be taken and that we be allowed to take these depositions and to prepare, even though it's, as I said, the case went forward yesterday because I had no choice. Thank you.
Thank you, counsel. Okay. Mr. Davis?
Yes, Your Honor.
You may
May it
proceed.
please the court. Thank you, Your Honor. My name is Jason Davis. I represent the respondent in this matter, Victory Lofts Association. And as the court has discerned, this is a typical attorney's fees and cost hearing. The underlying merits have been determined at the trial court level, at the appellate level, and entitlement was awarded at both the trial court and the appellate level. It was returned to the lower court for a determination on the amounts. And I believe Judge Kelly has hit on a fact that the trial court entered a very detailed fee hearing order. It's included in the appendix, pages 7 through 11 that were filed with the petition, required the prevailing party to provide detailed descriptions in its affidavits of the time and efforts it is seeking to be awarded as far as fees, of its costs, of the backup records. All of that has been provided to Lipsey Real Estate and Holdings. And the trial court's order on petition today specifically required that an attorney most involved in the case sit for a deposition. Now, for whatever reason, Lipsey Real Estate and Holdings chose not to take that deposition and instead to file a petition with this court. And simply put, the 2 points we would make is there is no harm when the petitioner fails to follow the order by the trial court, is allowed to take a deposition and either refuses to do so or waives the right to do so. And Judge Castanueva, I believe you also pointed out, what was the proffer before the trial court on a fee hearing? And I would put there was no proffer for the need to take a deposition of every attorney that has worked this file. Certainly was not a proffer to take a deposition of Mr. Penza or Ms. Gonzalez, who are not attorneys and are not seeking time entries to be awarded. And when the court allowed a deposition of the attorney from Shoemaker who had the most knowledge of the case and the petitioner failed to do so, I think that was a self-inflicted harm and certainly not something that is proper for a certiorari order. The other point I would make is that you always have, I believe, a remedy on these types of orders. Lipsey Real Estate and Holdings can certainly appeal the fee order if one is entered, an adverse order is entered against it to this court, at which time it can seek whatever relief it would like. This is just not an irreparable harm without a remedy. And certainly the second prong of what is required for certiorari relief is just not presented here. And I'd rather not belabor the point, but if the court has any further questions, I'm pleased to answer them. And hearing no questions, I would just ask that this court, we rely on our responses, this court deny the petition, and I would yield the remainder of my time.
Thank you, counsel.
Thank you, Your Honor. In rebuttal, the court, as is noted in the order, said 3 hours for attorneys, 3 hours per person. He didn't limit me in that order until we got to the protective order to only one attorney. I tried to take those depositions, and is noted in the appendix and as well as in the statements that there was on 2 separate dates that I had asked counsel to clear. And that was in January, don't worry. January 5 of 2021 and January 28 of 2021. I got no response from counsel in setting these depositions. When I did set them, there I was met after 21 days of them being set with a protective order. He waited that long right before the depositions with which to do this. Now, it's interesting that counsel states there was no proffer. Well, how can you make a proffer if you're not even allowed to have a hearing on a motion for a protective order? How does the court know whether, how could I make a proffer as to the necessity or the reason why I wanted to take Penza and Gonzalez, or it's very evident Ellis and Davis, who are attorneys, their attorneys, Bona Larson, who was throughout this entire case, made all these entries, and I'm not allowed. Now, what the other issue that counsel brings up is that being given that opportunity to take those depositions of single attorney, I did on October the 12th and October the 23rd. I emailed counsel. Now, I'm sorry, this is not in the record because the writ had already been filed and it's not part of the record. That I had emailed him to take the one deposition.
If it's not in the record, you shouldn't be
I
talking
understand
about
that.
it.
But neither is his statement that I didn't try. So
Mr. Lipsey, part of the issue here on the prongs for cert is irreparable harm. And the trial court granted you the authority to take a deposition. And arguably from that, you might be able to establish why others would be needed. And at this point, that is an unknown. But the order for cert has to be irreparable harm, a material harm. And you've been awarded a depot by the trial court's order, right? That whether or not you took it is immaterial. The order on its face provides you the ability to take a deposition.
I will agree with you, with your honor. They allowed me to take a deposition of one attorney. I was not allowed to take the depositions of the party or the party's representative. It limited me. And it said that all the other ones are quashed, and it says the parties on mutual agreeable date, the deposition of only one attorney of Shoemaker. The court did not allow me in that order to take the deposition of the party themselves.
The court did reserve jurisdiction, correct?
Excuse me?
The court did reserve jurisdiction over the matter, and it's an interlocutory order, which means theoretically further applications could be made.
Well, and the court, your honors addressed that in the other hearing, in the HEPCO, that it really doesn't matter if other revenues are available. The question is, what is done here? If I recall in reading appropriately, that the head note says, fact that order was without prejudice to petitioner refiling another motion to compel did not change the result. And the fact here is that if I had gone in and gone any further with any further motion, it still didn't change the result of what Judge Huey did. And Judge Huey's order does not purport to comply with the requirements of the law of finding good cause. He didn't state there was good cause. He didn't state any factual basis that would establish their need for this protective order. I won't belabor it any further than that, Your Honor. Thank you very much.
Thank you, counsel. Thank you both. Guess that concludes the presentation on this matter. And however the electrons work, they will transfer you back to your previous electronic location. And we'll move on to the last case on our docket this morning, which is, and I'm going to have a hard problem, I think, pronounce it Drotleff. Is that right? Drotleff? I'll ask the parties when they get here. Thank you very much.
Thank you, Your Honor.
All right. Okay, we have both counsel. Mr. Hobson, I think you're muted. You're not now. You represent the appellant, is my understanding, and I would ask you then, did you wish to reserve any time for rebuttal?
Yes, Judge, probably 3 minutes. I don't think, I spoke with Mr. Baseman. We do not think that we will need the entire time allotted for us. So 3 minutes would be all I would need, and if possible, rebuttal.
Very well. I will, if needed, let you know when you arrive at 17 minutes.
Thank you. I appreciate it.
You may proceed, counsel.
Thank you. May it please the court, my name is Peter Hobson. I represent Andrew Drotleff III as the appellant in this matter. In explaining that we do not believe, at least I explain, I do not believe I will need my time allocated. I don't want the court to construe this as that we do not believe, or I do not believe, my client does not believe, that the issue merits the consideration of this court. We believe, though, the issue can be distilled as found in the documents. The parties to this matter were married and divorced May 29th of 2013. It was the marital settlement agreement was the basis of the dissolution. The marital settlement agreement provided that the petitioner, who is the appellant in this matter, pay to the respondent non-modifiable durational alimony as set forth in the judgment agreed. Basically a 10-year agreement, and I'll go over the terms and provisions. In March of 2020, the appellant filed a supplemental petition to modify the final judgment and a motion to terminate the durational alimony. The former wife, through counsel, filed her response on April 16th. And thereafter, both parties, which both of these documents are parts of the record.
Mr. Hobson, let me ask you this. Didn't the marital settlement agreement also specifically state that the parties anticipate that the former wife may receive support from a third party in the future, but that will not be a basis to terminate alimony?
That is correct.
So the argument that the remarriage occurred and the legislature has addressed that issue because that is then a form of support, or there's someone else now involved. But in essence, your parties kind of addressed this, did they not? And that there could be future support coming. Wouldn't the marriage qualify as that type of support?
Well, what we think they stipulated to was the first prong of the two prongs for a supportive relationship. I believe in order to prove the supportive relationship, you have to prove the supplemental monies from some third party, and as a result, the benefit to the recipient and the lowering of the cost of living. So I think your point, yes, they stipulated non-modifiable alimony, and if they meant the non-modifiable alimony as it's normally construed, there would have been no reason to have that provision in there, because this is the platform upon which the confusion begins. Why have that entered in there if it is in fact non-modifiable, as they say? There would be no benefit, there would be no reason to insert that other than the fact that when they were talking about non-modifiable alimony, they may have been talking about it in a lot of different contexts and maybe carving out all these exceptions.
Well, often, I mean, belt and suspenders, a lot of times to make sure they're clear and you don't leave an avenue for someone to try to go down, you specifically state that, but because you specifically state that, you're now wanting to read into it that maybe there was an exception. Is that basically your argument?
Well, the basic argument is this, that if you take a look at the marital settlement agreement, that provision, and that is on the record, P39, basically they, in paragraph 4.2, discuss the provision that you just referenced. But then in the next page, page 40 of the record, they go on to discuss what are the components to the non-modifiable durational alimony. And even in there, there's modifications set forth that will occur by their agreement. The gravamen of our argument can be found at 4.6, which states payment of non-modifiable durational alimony as set forth above shall terminate on June 1st, 2026, or the death of either party, whichever shall occur first. What we're saying is that that is not exclusive language as to termination, 4.6. That in order to have eliminated the application of the statute, they would have had to insert only, the word only, or exclusive, some sort of language to that effect, that this is the exclusive methodology, because the case we had cited, if I'm pronouncing it correctly, a Burley, the 310 Southern 3rd, page 108 out of the 4th DCA, we're not approaching our argument from the standpoint of just a MSA, which talks about rehab, durational alimony and the termination. What we're approaching from the standpoint that whenever you have an agreement, a contract, which is going to be interpreted as any other contract, and when you have it in a family law setting, the courts, when applying the contract mindset to these contracts, it is important to have either facts which would lend one to believe that a provision is inherently or inadvertently addressed, or language that is exclusive in nature. We suggest in this case, there is neither. Even those
Well,
who can't continue recital.
Didn't it also go on to say that the intent was to provide the former wife with an economic assistance for a set period of time? Doesn't that kind of give us a window into what the intentions?
We believe that, but that at the same time, durational alimony is in and of itself, it's for a set period of time, yes, and at this amount. And we were talking about a termination of this agreement. And candidly, we believe that if paragraph 4.6 had exclusive language, then we would not have our argument. But because it doesn't have that exclusive language, as the court found in the case that I cited, in a different context, where there was no exclusive language, we believe that technically the statute was still in effect. Where you find that there's non-exclusive language, then the statute is still in effect. And the statute, as we all know, terminates durational alimony upon the remarriage of a party.
Mr. Hobson, I was preparing for this case, and one of the cases that everyone has cited is called Herbst out of this court. In doing so, I note that on November 5th of this year, the 5th District Court of Appeal considered a durational alimony question regarding non-modifiable language that appears in a MSA and found that language to be clear and unambiguous, and that non-modifiable means exactly that, so that the remarriage did not terminate the durational alimony. And it seems like if this case is not on point, it's rather close. I will also advise the period in time for rehearing hasn't passed. It came out November 5th. But if it remains valid, it would seem like the 5th District has moved Herbst and approved its reasoning along with others and applies it to durational and says, basically remarriage is something that's foreseeable, non-modifiable means what it means, durational is fine, and that's your contract, we need to do nothing more. That would seem to come against the argument that you are making now.
I think in this particular case, I'm not familiar, I apologize, I'm not familiar with the case that came out.
Well, the name of it is called Dills. And if anybody, if you don't have it, it's at 2021 Westlaw 5140865. And as I said, I was following up Herbst, and not that I knew that this was coming down the line, but I wanted to make sure I knew how we had followed Herbst, and I found this case also.
I think in order for that case to be applicable, and let me just, if I could just address Herbst, the case.
Okay, I just want to let you know that I found that.
And I do think that the trial court correctly noted in its finding is that the Herbst case is out of the 2nd DCA. And as we were arguing our case, it noted that the court was bound by the Herbst case because of the fact it was out of the 2nd DCA. It also found the decision to be controlling, and he found the factually more analogous to than the other case. I want to make sure I'm clear on that for the court. Again, I don't know about the case you cite, sir, but the question I had, or the question I would like to raise is, when we review these cases that address non-modifiable, even if they call it non-modifiable, sometimes they put in these different provisions, which in effect give you their definition or what the intent of the party was as to what is or is not modifiable. And again, if in this particular case, they carved out the exception of the death of the parties, and of course the date certain as being termination provisions. They also inserted the language regarding the financial support coming into play. So I think what they did is they kind of had a very broad definition of non-modifiable. In creating that broad definition, what they meant by non-modifiable, they didn't exclude termination by marriage under the statute. We believe that the decision of the non-modifiable, what is or isn't by non-modifiable, and whether you apply or not, it's by case basis, and you have to look to the facts of the case. And we believe in this particular case, it was broad enough factually that the trial court erred in not making a determination that they had not excluded the statutory provision of remarriage, in negotiating the marital settlement agreement and, of course, the final judgment that followed. Thank you.
Thank you, counsel. Mr. Baseman, you may proceed, counsel.
Thank you. May it please the court. My name is Mark Baseman. I represent the former wife, Tanya. She goes by Hartley to me, but I wanted to start by saying, look, it's always helpful to have what I think is a case that is exactly on point, and I think the Herbst case is exactly on point. But to delve immediately into the case law is almost missing sort of the obvious point here, which is these agreements are supposed to be interpreted based on the intent of the parties, and the way you interpret intent is to look at the language they chose. The phrase non-modifiable is not a Latin phrase, it's not a boilerplate phrase, it's not a foreign phrase. Modifiable means the ability to change, non means non. They agreed to non-modifiable, non-changeable alimony. They carved out minor exceptions to that, death and the date, June 1st, I think it was, 2026. Every single case, at least the ones I've found, and opposing counsel has not cited any alternative cases, every case where the parties say this alimony is non-modifiable except X, Y, Z, X, Y, and Z are treated as exclusive times where alimony can be modified. Anything else in the world is not grounds for modification. The Elbaum case I cite is exactly on point, where the parties said non-modifiable alimony, except in the event there's a change to the husband's business or his ability to make money through the business. And with that language, the appellate court didn't come back and say, well, because they gave some reasons it could be modified, they had to list every reason it can't. They said to find any other time where it can be modified is to eviscerate the concept of the phrase non-modifiable alimony. Mr. Hobson's argument is very similar to that. He's saying, well, they didn't carve out remarriage. But you know what? They didn't carve out supportive relationship. They didn't carve out a lot of things. What they did do in this case is say it's non-modifiable until it terminates in June 2026 or until either of the parties dies. I see nothing in here that distinguishes this case from the Herbst case or the new case in the 5th DCA that makes it very clear that the same rationale would apply to durational alimony as well. In Herbst, out of this court, the MSA unambiguously said non-modifiable alimony, and it said for the life of the former wife. And this court ultimately said that that was absolutely clear, unambiguous, that there are no other times where it could be modified. And that case was exactly the same thing. The former husband was arguing that he was entitled to modification because the former wife remarried. And this court said, no, you can foresee that possibility. If you want to carve that out in a non-modifiable alimony agreement, you have to do that. You didn't do that. Non-modifiable means what it means. It is not modifiable. I struggle to see any difference between Herbst and this case. Frankly, Mr. Hobson does nothing in his initial brief to even reference Herbst, let alone distinguish it. And I would ask this court to follow its precedent and simply affirm the judgment on appeal. I have no further remarks prepared unless there are questions.
Look, I don't see any questions, counsel, so I will say thank you for your presentation, and I will move on to stopping the clock and then letting Mr. Hobson know he may start his rebuttal. Counsel, you may proceed.
Thank you, Judge. I don't think that there are minor revisions to the non-modifiable provision. I think there were major provisions, and the major provision was when they said the financial assistance would not be a basis for termination. They were basically talking about, they could only be talking about one thing there, and that is the first element of a supportive relationship. Secondly, the Rosenthal case, which was cited by the appellee, and it basically it is of interest because in that particular case, the former husband argued that the trial court's determination was erroneous because the marital settlement agreement in that case contained neither an explicit waiver of the right to modify nor unambiguous language demonstrating the intent of the parties to waive the modify the right to modify the alimony award. Now, that case goes on to note that the right to modify awarded alimony may be waived by either party. This waiver may be implied. However, an implied waiver must be clear and unambiguous. Parties may waive the right to seek modification of settlement agreement if the language is clear and unambiguous, and the interpretation could lead no one. If the interpretation of the waiver as a whole can lead to no other conclusion but a waiver. He also cites the Embalm case, and I agree the Embalm case is a good case in support of their position. But the problem with the Embalm case was not from my standpoint. The problem is that it's noted that in that agreement, it references that said alimony shall be non-modifiable by the parties in either amount duration, regardless of any change of the circumstances of the parties. Remarriage would be covered by that, regardless of any change in the circumstances of the
But
parties.
wouldn't remarriage be something that would be reasonably contemplated in the future after a divorce, so that if you were writing a marital settlement agreement, you would cover that likelihood?
I didn't write it, thank God.
Okay, fair
But-
enough. But I noticed that
I understand what
the
the
Ebon
court's
case
saying.
was the fourth, if I recall correctly, and that would be Judge Gross writing, I think, for the fourth on that case. And he pointed out, if I have the right case, that there were some exceptions from the general rule of non-modifiable. And he said, those are the only ones, because those are the only ones the parties contracted for. Do I have the right case?
Yes, I agree with Mr. Baseman. Judge, one other thing too. I'm not suggesting that this is a clear. I think the marital settlement agreement, and we argued that marital settlement agreement was not the best drafted agreement for a number of reasons, and that there had been some other issues that were related to a reflection on the agreement. So I'm not suggesting that I agree with the court. It would have been perfect if they had language in there that would have made those two provisions, the date certain and the death of either party, as the exclusive, in addition to the previously stated reasons. But that wasn't the case. And my question to the court is, what happens in a contract when you leave that possible door open for interpretation? Thank you.
Well, and I'll go back to my first question then. In the absence of that, and we have such express language, wouldn't it have been incumbent on the parties, if they didn't mean non-modifiable, and if they didn't mean that it was for a specific duration to benefit the wife, that it should go in there with those exceptions?
If I understand the court's question, it's shouldn't the language that remarriage does not. I'm not going to, I agree with making it clear. The question for the court is a little different than that. The question for the court is, if you begin an alimony provision by saying that if the alimony is not modifiable, you don't have to repeat. You don't have to put it in there. If you put it in there, what are you doing? You're creating something in the back of the minds of people. I think what they were saying was this would not be the basis for termination. I understand that. You go to the next page, they give you the alimony step down payments, and then come to the paragraph in question here about what happens when there's a date certain, when you reach the date certain and or the death of either party. It terminates. But again, the question is, when does the language of an agreement specifically eliminate the provisions of a Florida statute on point? And I suggest it has to be clear. If they said it's clear language, then that statute would not kick in. I think under the case that I cite, if I'm pronouncing it correctly here, Malice, it's to that point, it says in order to exclude the provisions of the statute, you have to be clear. Thank you.
Thank you. I thank you both for your presentation today, and on behalf of the court, wish you well, stay healthy. We hope to see you in the future in person, God willing. And that will conclude, I guess, our docket for today. I will let counsel return. I have sent panel members an inquiry. So if you would, I know I have one answer and I just need one more, and then I will do the thing about our conferencing. Take care, please, everyone.